50.
Exactly.
You have taken consent of the other side? You have taken consent of the other side?
Yes, Your Lordship.
Okay. Consent of the other side?
It may be adjourned for 2 weeks, Your Lordship.
Yes, sir. Your name is PP Saikia.
I'm for Mr. PJ Saikia. I'm KJ Saikia, Your Lordship.
KJ Saikia, counsel for the respondent numbers 1 and 2, place for adjournment. There is a lot. List after?
2 weeks, Your Lordship.
After 2
If
weeks.
possible, Your Lordship, 9th of June, Your Lordship. Or any other date.
Contempt matters, I'm not fixing a date, but 2 weeks and just making a mention.
Much of that.
Okay.
Thank you.
May I please, Your Lordship? Lordship, with the consent of other side, I wish to mention item number 35 to 40, Lordship. Lordship,
35 to 40.
yes, in this matter, Lordship, we are going to file our affidavit today itself, Lordship. So matter may be taken after 1 week. And it will be direct to bring it record.
Counsel for the Water Resource Department submits that they would be filing affidavit in opposition in this matter in course of the day. Full stop. Just mention both sides are represented. List after week is paid for. Okay.
A date may be given, Lordship.
35.
9/6.
Yes. Okay.
Supplementary cause list, item number 68 for motion.
Oh, that affidavit is not come, but you'll have to give me a copy if you
Yes,
have
sir.
one.
There's a reply also, reply affidavit.
Yes. Both sides can furnish me a spare copy if you have.
Lordship.
Both sides can supply me a spare copy if you have.
Yes, we have submitted. A reply on the
Yes, Mr. Goswami.
এখন আমার হয়নি
Yes.
Your Lordship has seen, we have challenged an order of requisition. Dated 25/4/23 at page 32. I propose to divide my arguments into 3 parts. First of all, Miller, I'll take the Lordship. I bless this into an order, Miller.
Yes.
Page 22. What I propose to do, Miller, take your lordship through some of the facts. Then I'll indicate from the affidavit filed by the state government, by the deputy commissioner, as to what is the nature of the plan, which is not yet finalized as per their affidavit because the project report is under preparation basis. And then I will come back to the order of the deputy commissioner, so that your lordship has a full perspective to judge whether the conditions required for exercise of power under Section 3 of the 64 Act has been met, whether there has been application of mind to the relevant facts, and what is the effect. That is how I proceed. So far as the organization is concerned, that's a simple matter. It's an All Assam Lawn Tennis Association catering to the needs of tennis for a very long time. Basically, the junior hub of tennis to start with really was in that Nehru Stadium. Few courts that was exclusively meant for junior tennis. At some point of time, the sports department wanted that to be built for some other purpose, therefore those was acquired. Then the state government allotted in 1999 and also 2003 plots in this particular area for in favor of the association for the purpose of establishing a tennis complex. Now, the order will place allotment orders. That said that if you don't do anything within 3 years, it will get reversed. They'll have the right to take it. But we have completed this thing. In fact, the state government help was very much appreciated even now, because by the time the construction and other things are going on, the 2007 National Games was coming up. Therefore, we got the maximum help, financial and otherwise, from the state government, and that's something which the association still appreciates. Now, over the years now, we have about 7 courts, 4 or 5 of them with floodlight arrangements, and 4 coaches. And there is an agreement with some German company now who is supplying the head coach, who comes at intervals, so that will not be students also, the young players also get the benefit, and also the coaches get the benefit. And about 350 boys and girls are taking coaching in this, and it's a very live sort of complex now. And it is one of the best, because the National Games tennis was there, and we have detailed the yearly events, which are national and international also, where the tennis tournaments are taking place. So it is a full-fledged tennis complex, of which this is the only kind in the Northeast and one of the best in India. That is what I am told, and what I have seen from the stadiums in complexes in Calcutta, with the famous South Club, and also the Delhi Lawn Tennis Association courts. I mean, this is as good as any. In fact, after reading the affidavit of the government, I was reminded of this Delhi Lawn Tennis Association, and I will appropriately tell your lordships at the right time as to what is the similarity in between the two complexes. But this is what it is. So it was going on very smoothly until we get this notice below, first of a survey and then a requisition. Now we have the benefit of the documents preceding this particular impugn notice. The letter which is mentioned there, that is now filed as an annexure A. And there was a meeting minute of 25/4/23. The minutes are also enclosed, that is at page 39 of the government affidavit. So and the affidavit of the DC has come now. And then from these documents, we find the position that this meeting decided, I replaced that document. That meeting decided, took certain decisions. I replaced that and then it will speak for itself. Pursuant thereto, the housing committee wrote that letter of 3/3/2023, which is now your lordship finds that mentioned in the impugn order, and now in the state government's affidavit, it has come, which is at page 36 of the affidavit. I'll take your lordship with that. So the meeting took place, then the housing department's letter comes, and then, my lord, this impugn order is passed by the deputy commissioner. It is on the same day, in fact. My learned is right. The impugn notice is 25/4, and the minutes of the meeting is also 25/4. So how it was done is, I'll take your lordship through that process. But now the affidavit may not indicates the proposed scheme or plan for this area in which there are two parts to it. It is one, the water body, Silsaco bill, which is from the main road, by the side of which the tennis complex exists. You have to go about 2 kilometers, about 1.5 to 2 kilometers. Now, from the government affidavit, it is seen that there was encroachment, and they have taken steps right from 2015 to clear the encroachment. And they say in the affidavit that therefore the position regarding flood has improved, and that work is going on. Now, two things are clear, that reservoir and the clearance of the encroachment and all other steps taken for purifying the water are in respect of that water body, which is situated at a distance of about 1.5 to 2 kilometers from the tennis complex. It is inside. This tennis complex, without your lordship sees that VIP road, it is just by the side of that. The first building of that complex office. So the other thing which I find from the affidavit, there is no allegation against this tennis complex as such, either as a contributor to flood or as an impediment to any process that they want to carry out with regard to that waterway. I'll take your lordship through the evidence. Your lordship will not find it. So factually, that is the position. And they say that what they are going to do about it. There is a scheme, the DPR is being made, and the scheme is below of a cycling track, a big jogging, boating, and then a big pillar with a cafeteria and things of that kind. I'll take your lordship through that. So that is the scheme. The reservoir is there. We are not part of that reservoir. It is not going to be dug again another reservoir, but they have a plan of this kind of things of entertainment or physical activity, whatever one wishes to say. And therefore, this complex has to go. I find that very strange, with great respect. The full-fledged tennis complex, if you can put bicycling there, jogging there, what harm would this cafeteria there, what harm would this 7 courts with the people getting coaching effect? I don't know. Anyway, that is what it is. And therefore, I'll take your lordship to that meeting on 25/4/23. And on the same day, the order of requisition is passed. Referring to the earlier letter of 3/3/23, which is at page 36. I'll place that. And your lordships will see how the statutory authority responsible for the requisition has exercised the power under the Act. So in a nutshell, below, this is the situation. And what I propose to now take your lordship through, first, our writ petition. A few paragraphs, then the government reply and the 2 documents, and then make my submissions with regard to the inadequacies in the imperial order. We have given the history of this club that I don't want to trouble your lordship with. I've already submitted that part. And what this club has that we mentioned in paragraph 5 at page 7. I have already indicated that. So 7 courts, 4 with lights, then paragraph 6, 350 players, and then below page 8, paragraph 7, the 6 qualified coaches which are there, who are led by a head coach provided by Alexander Waske Tennis University, Frankfurt, Germany. So all this is going on. And we have produced top ranking tennis players who are within the top 10 in the country. And all that is mentioned at page 8, paragraph 7. That's the position of the complex. And at page 9, the yearly events, apart from the national games which we have, where without it was played, 2007 that was. The tournaments which are regularly held on a yearly basis, your lordship will find at page 9, about 4 tournaments, all India tournaments and some international tennis federation tournaments. Then advanced coaching and all that. With make investments about 5 crores and more. Then we got that notice from the cycle officer on 31-3 for a survey. And then we received on 3-5, paragraph 9 at page 9, the impugned order 25/4/23 on 3/5/23. For five bigas regulation. I requested the document, therefore I need not have any other options. Now, some of the paragraphs now I will this. Paragraph 10, page 3.
Yes.
That the petitioners were surprised with the aforesaid move of the respondent authorities as the lands for construction of a reservoir in Silsaku has already been cleared. Moreover, the adjacent land has been designed to be a highland. Next plot, they are filling up the land, highland to the reservoir. That about the petitioner further states that the reservoir, the land and the building of the petitioner associations can harmoniously coexist without interfering with the objective of mitigating urban problems. This is their reply, your lordships can just have a note straight away. Paragraph 6, page 28, no comments. And then we go to the formation of the opinion. We say it is not there. That will be a legal submission that I will make. On the factual part, I am only now trying to show. Paragraph 12. At page 11, that the petitioner respectfully submits that from the impugned order dated 25/4/23, it is clear that the requisition process have been carried out in pursuance to letter dated 3/3/23. Though the letter dated 3/3/23 has not been furnished to the petitioner, however, it is clear from the impugned, this has already come in the government affidavit, which is at page 36. Though the letter dated 3/3 has not been furnished to the petitioner, however, it is clear from the impugned order that the power has been exercised under the dictation of the Department of Housing and Urban Affairs, that under section 3, the deputy commissioner cum collector has to exercise the power as a collector defined under section 2A of the aforesaid act. If that be so, then the deputy commissioner was exercising statutory power, and the deputy commissioner cannot exercise this statutory power under the dictation of any authority, and therefore, in the above facts and circumstances, the above impugned order, this is a legal submission which I developed after I placed these facts. Without independent application of mine of the deputy commissioner, therefore, the impugned order suffers from non-application of mine and is illegal. These para 12/13 also. It is submitted that the aforesaid land was allotted in the name of the petitioner association on resumption of the said land from Indian Tea Association on the ground of non-utilization of the said land within 3 years, with a condition that the allotment will be reverted to the government automatically if not utilized. That is the condition of the allotment. We have fully utilized the land, therefore that question doesn't arise. However, the land has been utilized as a tennis complex. In the said complex, hosting budding talents and beginners in the game of tennis, over 350 players of the different age groups from 6 to 18 are undergoing regular coaching in the said campus, with several regular coaches organizing regular tournaments as highlighted in the previous paragraphs. Therefore, the condition for reversion of the land to the government has not arisen. Therefore, the act of retribution by exercise of power under section 3(1) of the said act and 4(1) of the allied rules is contrary to the allotment order itself and is liable to be set aside and quashed. The right to attain, we are then saying that you have to form your own opinion in order to exercise that power under section 3. Formation of an opinion of the statement followed by an independent application of mind by the statutory authority before passing any order of regulation. The aforesaid preconditions are apparently missing in the impugned order dated so. Therefore, the action is unreasonable, unfair, and high-handed, and is liable to be set aside. Then, my lord, the tennis complex is situated just beside the main road. The land next to the tennis complex has been carrying out arch filling activities. Land close by is under installation of a gas cracker project. The lands to be used for making a reservoir have already been dug. That is the bill, my lord, which was encroached, and they have cleared that according to their own affidavit. From the aforesaid facts and circumstances, it is apparent that the land of the petitioner would not be used for the purpose of a reservoir. That is what we were saying, and now it is confirmed. These three paragraphs, my lord, 12, 13, and 14, the government affidavits deal with that at para 9, page 34 of the government affidavit. I will place that. I am only indicating that this is virtually remains unrebutted. I will place that, therefore I am indicating that. And this paragraph also is important, 15, which I have already placed. And if paragraph 15, which I have just placed, page 13.
Yes.
And the reply of the government is at para 10, page 34, no comments. I will place their affidavit, but I am indicating there's a no comment by the government affidavit. Then para 16, that the actual reservoir for which the entire requisition process is to be carried out is not in the land occupied by the petitioner, and the land of the petitioner doesn't fall within the area in which the reservoir in Silsako Bill is proposed to be set up. The land adjacent to the petitioner's land is being filled up for the purposes other than building a reservoir in Silsako Bill. Therefore, the order dated 25/4/23 doesn't reveal the actual scene, and even if the reservoir is built, the complex of the petitioner can carry out regular activity. The requisition of the land of the petitioner initially allotted for a public purpose and utilized for a public purpose is unreasonable, unfair, and suffers from non-application of mind. This is again, your lordship may note, there is no reply. That the impugned order suffers inherent defects. Firstly, the condition precedent for exercise of the power under 3 is absent and would vitiate the proceedings being without jurisdiction. Secondly, the tennis court in question is a great public interest, and as such, requisition as contemplated is inconceivable in the facts of the case. Thirdly, the complex in question can coexist with any measure taken for flood control. That apart, no reasonable person could have included the act in question to destroy and a fully built tennis complex built with the contribution of the government. Public money was spent by the government for this. And the reply your lordship will find while dealing with para 7, they say refer to their own affidavit in para 5. I will place that when we finish this. Then 18. That is the schedules of the Water Budget Reduction Act. There is Sorsula Bill, Borsula Bill, and Silsako Bill. There are many eminent structures in Soroshala Bill and Borsala Bill covered by their respective guts. However, the respondent authority in a pick and choose manner has tried to initiate action against the petitioner who do not even fall within the reservoir proposed to be set up there. Therefore, the action of the government is apparently discriminatory and in violation of 14 and 21 of the Constitution. This again, no comments in the affidavit. So this is in substance our case. Basically, we know that we have not been a part of the reservoir, nor we didn't know about what their proposal is. We thought that reservoir cannot come right beyond up to the club complex over a period of over a land area of about 1.5 kilometers. And that's not their plan. That area is a distinct area under the Act also. And they have cleared that. That's what they are saying since 2015. Therefore, this is in substance our case, and I'll just take your lordship to the allotment orders. Your lordship will find the 5 bigha, which is under requisition, is at page 20, next B. It was earlier allotted to Indian Tea Association. They did not do anything. Therefore, it went back to the government. It says that, and then they are giving it to all Assam Tennis, subject to the condition that the land should be utilized for their specific purpose within the period of 3 years of allotment, failing which the same will be reverted to the government to Revenue Department automatically. 1 copy each of the test map and chithas of the land received with your letter under reference are returned herewith for formal handing over possession of the land of Tennis Santha and correction of the land. That's normal orders. And then the other 3 results at 21. And then this is the impugn order dated 25/4/23. In exercise of the powers conferred on me under section 3(1) of the Assam Land Requisition and Acquisition Act 1964, under notification number so dated 15th July 1993. Already the commissioner conferred this power under the Act. I, so Deputy Commissioner and Collector Kamrup, Metropolitan District, Guwahati, do hereby requisition under section 3(1) of the Assam Land Requisition and Acquisition Act 64. The land described in the schedule below, along with the buildings standing over the land, with effects from the date of this order, for the purpose of development of Silsako Bill as a reservoir and facilitated the mitigation of urban flooding in pursuance of the department's letter of Housing and Urban Affairs dated 3rd March 23, which now we find at page 36 of the government affidavit. So this is the order of requisition passed by the Deputy Commissioner, and I'll take your lordship. The next page, under the rules, asking us to deliver a handover for that. So this is all. Now, if your lordships take up the government affidavit for a moment. There are 5 below, page 27. Okay. Para 8, new comments. Then para 5.
Mr.
As
Goswami, if you can concise your argument, I'll be happy because today is a motion day. I have a long motion. You can concise your argument. I am following it. I'm making a note.
I just a few paragraphs.
No, I'm not stopping you, but I'm just
I'll
asking to
try to
concise.
be very brief, but I understand your lordships are taking the final hearing. Therefore, I have to place the case. I don't want to put your lordship into difficulty.
No, not that because you see, Mr. Goswami, I have absolutely no misgivings. I can continue the hearing. There is no issue. But since there are so many lawyers and so many motions,
That's
yeah.
right. I personally do not like that also, but my.
No, I understand. That's why I'm just- I'm just- it's okay. I'm just
Your lordship feel that.
no, not that, not at all. But if it can be concise,
No, I will be concise, but I need to be a factual situation.
no, I'm not stopping you from arguing.
I'll keep it clean. Normally, I am not very lengthy. Because this paragraph is crucial for them, that's why I am placing it. Fine. That as regards the statements made in para 9 of the writ petition, the opponent herein begs to state that the Joint Secretary to the Government of Assam, Department of Housing and Urban Affairs, dated 3/3/23, requested to initiate acquisition proceedings in respect of 17 institution organizations for clearing obstruction at Silsako Bill and to develop as a reservoir and to facilitate the mitigation of urban flooding. Accordingly, the same was sent to the circle officer, Revenue Circle, for conducting a joint verification with required body, that is the GMD, and to submit a LA proposal by later dated 3/3/23. In response, the circle officer, Dispur Revenue Cycle, via his letter dated 21/3/23, submitted a proposal for acquiring the plot of land allotted to All Assam Tennis Association, and accordingly, land was requisitioned on 25/4/23 by so as per the provisions of section 3(1) of the Act. As regards the statements made in para 10 of the writ petition, the opponent herein has no comments to offer so far as the same are matters of record. However, anything beyond the records will be treated as so and so. So your lordships kindly note this, how this order has come about. First that letter, then he writes to the circle officer. The circle officer in his turn writes to him that requisition acquire the tennis complex, and he passes on one. Wonderful. Then it is pertinent to mention that the high-level meeting took place on 25/4/23, which was chaired by the Honorable Chief Minister of Assam to discuss inter alia about the Silsako Bill project as is reflected in the minutes of the said meeting dated so. Of our trade fair discussion, certain decisions were taken, which includes the land acquisition proceedings to be initiated in respect of those who have made permanent structure, and they would be entitled for only Jirat as the land has not been settled. In terms of the decision of the said meeting that it's so, the acquisition process was started in terms of the provisions of the Assam Land Acquisition Act 1964, and the said order of acquisition was issued on 25/4/23. Then, Milord, this is important. They are mentioning what the problem is at page 29. It is pertinent to mention, second paragraph herein, that Silsako Bill is a significant wetland on the eastern part of the urbanizing metropolitan Guwahati. Although the wetland has legal protection under 2000 Act, other directions of the Honorable National Green Tribunal, it has remained vulnerable to the threats typical of any urban area, namely urban encroachments and untreated wastewater influx. These are problems which are for the existing bill, which is covered under the 2000 Act. The bill area has thus shrunk considerably and its water quality has deteriorated. Then we note that in the year 2015, excavation commenced in the large marshy riparian area of the east side of the bill, partly to protect the area from encroachment and partly to create a major flood moderation reservoir. At the same time, a bypass channel was created to trap the wastewater flow emerging through various drains and discharges of the same to the downstream side of the bill. The northerly discharge empties into Brahmaputra River, and as such, the National Green Tribunal stepped in directing the treatment of waterways presently discharging into the Brahmaputra. Hydrologically, the bill receives harmonious amounts of surface run from so. All this is pertaining to the water there, and they have taken and bill and is causing frequent floods. This is important. Huh? The bill receives a homogeneous amount of surface runoff from its 50-kilometer catchment. The surface runoff is laden with silt, which has reduced the retention capacity of the bill and is causing frequent flash flood in the neighborhood area. Accordingly, Guwahati Municipal Development Authority has initiated excavation in an area approximately 300,000 square meter and is observed. It is observed such excavation is showing prominent result during the last flood season. So this is concerning that bill, which is away from our complex. It is also pertinent to mention that for rejuvenation, biometrication, and sustainable conservation of the bill, the government of Assam is initiating a project by already preparing a detailed project report to be implemented through the JMDA to address the following complex issues. So there is now excavation of the bill area to increase retention capacity of the bill to at least 35 lakh cubic meter to reduce the flash flood in the surrounding areas. Treating the wastewater inflows to ensure standards compliant discharge of Honorable NGT order to Brahmaputra, ensuring that excavated area has a perennial water spread and shall act as a groundwater recharge zone to have sponge city effect, retaining the biodiversity elements of the bill, recovering encroached land along the bill channel, creating urban green and blue public area with recreational elements. Kindly note this. The project is thus combination of three interlinked features. The original bill channel around 3,000 meter long, the excavated lake of 500 square kilometers spread, the bypass channel for sewer on the south, east and north of the bill, 1,400 meter long. So these three, we are not, it is not, there is no allegation that we have anything to do with these areas or in any way impeding any of their steps concerning this area. This is entirely an area which is away from us in the bill area, and all that they are proposing to do or have done is always a good measure, and in that we are not in any way an impediment. That allegation is missing. In fact, in our area, the courts never had floods. If you have floods, of course, the whole complex will go off. So we never had the floods. We have said that. The project plan also includes the following elements. Apart from all this, what I would like to, these are all the excavated lake, the water quality, that is with regard to that bill only. Sustenance of the bill is just admitting the monsoon surface runoff through a system of sluice gate, the partiality partially excavated lake is to be further excavated as per an excavation plan to ensure a biodiversity responsive profile. All this is there. The bill is proposed to be further widened and deepened. A minimal amount of water from the lake would be gravity and all that stuff. Landscape elements including plantings, grasses and sloping banks and embankments for stabilizing. All this is with regard to that bill. Two circular islands of about 1 hectare each are proposed in the lake. The northern island would be a nesting island for birds. The southern island would be a recreational one with an interpretation and monitoring center, 40-meter high viewing tower, cafeteria, and recreational elements, boat jetties, parking areas, walking, jogging, and cycling tracks would be provided to make the project self-sustainable. This is the part I am on, my lord. These are things which are good in themselves. You need to have a boat jetties, parking areas, walking, jogging, cycling tracks, everything is all right. If all this can be created on this land, why disturb this complex? That's the whole question. And not at our cost that you will be doing this. It can be a substitute for the tennis complex. Secondly, the person who is exercising his statutory power therefore has to apply his mind that what is going to be done. Was he aware? Did he apply his mind to that aspect? So it's a question of balancing the competing public utilities. One which is already in existence, one which was backed by the government's money, partially, along with others, and which has been there for the last so many years. Why you destroy this for all these recreational provisions? Was the Deputy Commissioner aware of this? Did he apply his mind to this aspect?
Does not allow to do.
And did you see whether it will be reasonable as a man to apply to take away the existing building to bring about all this? These are matters of application of mind to relevant facts.
Does not allow.
I'll place section 3.1. The purposes are also mentioned there. These are condition precedent, as your lordship sees. And you must be aware that this is what is going to be done. There is nothing to indicate that the Deputy Commissioner was even aware of this thing before he passed the order. He doesn't say that I have applied my mind to it, I have considered it, and I find that this complex has to be requisitioned and then pass the order. That is absent. And this is something, my lord, which is akin to have work of which we are doing. What is the tennis complex, my lord, for juniors? We are coaching, people are getting a facility. We are talking about youth going astray. You are putting these people into a very good stadium with coaches. So it's a very good project, my lord, from the point of view of sports, from the point of view of social, my lord, environment, everywhere. And all these can coexist with a tennis complex. That's what I was trying to say. The moment I read this, my mind flashed back to this DLPA. Your lordship may have seen that. The Africa Avenue goes, just like our VIP road. Next to it is the stadium complex with all its courts. And after the thing, there is a inner road that goes to that lake. And that is a huge lake of Mughal area possibly. There is a plaque there suggesting that. And a walking, jogging track. And then lawns. People can go, small kids go there, play there, have picnics. And next to it, there is a mini zoo where you find deer, these peacocks, all that stuff. So it is not that the tennis complex will in any way has been affected. That came later on, and it is all are coexisting. These are matters which can coexist. Then that's a very relevant aspect when you are dealing with a full-fledged complex running for so many years and providing coaching to so many people, including the yearly tournaments, national and international. It will be a disaster if this is stopped for only these elements of recreational elements. You have all this, but it can coexist. There is no problem about it. Jogging is good, boating is good, cafeteria is good, but it's not a substitute. All these can coexist. The Delhi Tennis Club, they have a cafeteria. They have now even built some rooms which are let out. A restaurant where people can go and eat. So we must view the matter in a broader perspective, you know. Silsako bill by itself is a way. It has its problems, they have taken steps, it's all for the good of the society. And that can continue. And what is these arrangements, it can also be there. There is no problem. So this is the aspect, which I will emphasize. And then when I address your lordships on the satisfaction of the Deputy Commissioner, this is the material which I will place for your lordship's kind consideration. Now, if your lordships kindly have a look at, and then page 34, they are talking about the detailed Craig's leaf of this court to place the detailed project report of the above mentioned project at the time of hearing and also to file a detailed affidavit if required. And then again, next paragraph also, they are talking of a comprehensive affidavit encompassing all the issues if so required by the government. And this para 9, I have placed para 12, 13, and 14 of the writ petition. This is their reply is of the petition, deponent herein begs to rely upon the statements made in paragraph 5 of this affidavit in opposition. Paragraph 5 is page 27, I have placed before your lordship. And now kindly have a look at these two documents, Annexure A and B. This is the letter we find in the impugned order, referring. This is the letter from the Joint Secretary to the Government of Assam, Department of Housing and Urban Affairs, the school, to the Deputy Commissioner, Kamrup Metropolitan Evictions Operation at Silsako Bill, which refers to the subject, it is dated 3rd March 23, which refers to the subject cited above. I am directed to inform you that the details of number of structures demolished and the quantum of land free from encroachment around Silsako Bill has been submitted by CEO ZMD. It has also been informed that 17 institutions, organizations were allotted land by the government from time to time. Since clearing of the obstruction to Silsako Bill is of immense importance acquiring of the properties allotted land by the government and payment of due compensation for the construction is imperative. Hence, you are requested to undertake the necessary steps for starting the acquisition proceeding in respect of the 17 annexure 1 institutions, organizations as per regulations. This issues with the approval of the Honorable Chief Minister of Assam. This is on 3rd of March 23 by the Secretary, Joint Secretary to the Department of Housing to the Deputy Commissioner. Now, this is what triggers the requisition. And then, my lord, your lordship, have a look at the meeting which took place 25/4/23. This letter is of 3/3/23. And this is of 25/4/23. It discusses several issues, my lord. One of them is Tilsako project. The decisions that are taken are mentioned. Silsako project, that is the item 1. After threadbare discussion, the following decisions were taken at the meeting. Silsako project, DC Kamrup to initiate the process of taking back allotted land from those public agencies, institutions that have not utilized the land for which the land was allotted. That is one category, we don't come under that. Those public agencies, institutions that have partially used the land allotted to them are to be asked to return the unused portion of land in the interest of project implementation. JIRAT can be paid in respect of semi-permanent structures that have been erected. So this category also doesn't cover us, but it shows that even if you have partially used, the remainder is taken. So that is the decision. Then 3, land acquisition proceedings to be initiated in respect of those who have made permanent structure. They would be entitled for only JIRAT as the land has not been settled. So this is 3 years if you have made permanent structure. You can't stress this to the existing tennis complex of 7 courts with the incidental change room and all that is required for a tennis complex. So it could not have been the intention, you know, to think that this is a permanent structure, therefore it has to go. One doesn't think in terms of a permanent structure, you know, when you come to think of a tennis court or a judges field or Borsapara cricket stadium. We don't say it's a permanent structure, we say it's a stadium. You require spectators, you have obviously galleries, you need many more things for the players, change room and all that stuff. So these are part of the main thing is the complex of cricket or tennis or football, whatever it is. You see, you don't refer it to a permanent structure. It's a stadium, ultimately. Either tennis or football or cricket or whatever it is. Badminton, all this is ancillary, the other things. Now, if you take this under this, and you have a plan of having a recreational activity with a cafeteria, with jogging tracks, and with a cafeteria and a big viewing tower. Good. One has to be rational and reasonable in these matters. So 3 also, in my humble and respectful submission, cannot be applied. Land parcels, then 4 land parcels against which Miyadi Pattas have been issued. If falling within this, it doesn't apply to us at all. We'll provide specific information to the DC Kamrup about the properties out of settled land that are essential for the project to be completed. This also doesn't apply to us. All such institutions with whom land was settled or to whom land was allotted initially, but who have subsequently been allotted land by state government elsewhere, that also doesn't apply to us. 6 is GMDA will prepare a list of encroachers whose land parcels are located within the row right of way of the project plan in the first phase, and DC Kamrup Metro will take action to remove such encroachers expeditiously. It doesn't apply to us. 7 institutions in possession of land on the left side of VIP Road towards Narangi from 6 miles should not be disturbed now. These land parcels not to be included in the discussions in future presentations. A revised plan of action to be prepared based on the decisions taken today. The plan will be discussed at the next meeting on 15th of May. This is all with regard to the area in question. We do not come within any of these decisions by respectful submissions. You can stretch it. We are given, we have fully utilized. And there is no allegation anywhere in the affidavit that because of this tennis complex, there is difficulty in carrying out our projects or that it is leading to flooding. If flooding takes place, we will be the first sufferers. It has never happened. And Sidhako Beach remains a mile and a half at least beyond us. We don't disturb anybody. All their plans, so far that bill is concerned, we have nothing to do. There is not even an allegation that we are in any way impeding any of their works. Nothing, absolutely, in this decision. Now, in this context, my lord, let us have a look at this section. Your lordship has seen how this has come about. The MDA list, then the circle officer is asked to survey. He says that acquire, DC passes an order. Wonderful. Now let us look at section 3. If in the opinion of the state government or any person authorized in this behalf by the state government, we are not concerned with the state government. It is by a person who is authorized in this behalf by the state government. In the impugn order, he mentions that notification of 93, empowering the deputy commissioner to exercise the power under section 3. So he is exercising that power. He is the statutory authority for 3 as far as this order is concerned. If in the opinion of the state government or any person authorized in this behalf by the state government, it is necessary so to do for maintaining supplies and services essential to the life of the community, that is 1, or for providing proper facilities for accommodation, transport, communication, irrigation, flood control, and anti-erosion measures, including embankment and drainage, or providing land individually or in groups to landless, flood affected or displaced person, or to a society registered under the Assam Cooperative Societies Act, or a company incorporated under the Companies Act, formed for the benefit of rehabilitation of landless, flood affected or displaced person, or to provide land for the purpose of construction of border fencing and allied works, including border roads and checkposts connected therewith along Bangladesh border, the state government or the person so authorized, as the case may be, may by order in writing requisition any land and may make such further order as appear to it or him to be necessary or expedient in connection with the requisitioning. An order under subsection 1 shall be served in the prescribed manner on the owner of the land, where the order relates to land in occupation of a tenant, also on the tenant. Where the order for acquisition is made by any other person, any person interested in the land within 30 days from the date of may appeal to the state government, and the decisions of the government in such appeal shall be final. So, my lord, this section 3 is a section which courts describe as conferring a discretion in subjective terms, namely a subjective satisfaction, which has to be arrived at in respect of the objects which are mentioned for which this power can be exercised. So, when the DC is taking up the matter, he doesn't have to go to the circle officer's suggestion or the joint secretary's report that requisition these lands, these institutions. If he does that, he is acting at the dictation of somebody else. 1, 2, he is not applying his mind independently, which is the cornerstone of a subjective satisfaction requirement. If you don't apply your mind yourself, your order is vitiated. That's the subtle law as far as subjective satisfaction is concerned. His power is couched or restricted by the objects mentioned therein. Now, under what category will he exercise this power? He can't exercise the power just because another secretary tells him or the circle officer tells him. And what for is he building? Is he aware? He is talking about a reservoir. The government affidavit doesn't say that this land is required for a reservoir. It says that we want to do these things: jogging, recreation, cafeteria, cycling. Are you aware at the time you are passing this order? Have you said that? We have specifically alleged in our writ petition that he did not apply his mind, independent mind, to the relevant facts. He doesn't say anything about it. He is silent. Which clause will it come? Nothing. Flood control and anti-erosion measure, that has a meaning of its own. Dibrugarh, a special Assam Act was passed for Dibrugarh. At one time. These are totally, and I could have understood if the government said in their affidavit that, look, this is what we want to do. The existence of these institutions or this tennis complex is posing as an impediment, and it is causing flooding. No word, none, no affidavit, no statement. And on the contrary, they are giving what they are proposing to do. Is this power available for creating substitutes? Look, it is absolutely clear. I don't find in his affidavit that he was aware of what is going to be done there. He is being told that you will start the acquisition proceeding first by the circle officer and next by the joint secretary, and he does it. Careless non-application of mine affecting the rights of very many people. I can understand, because if we are, as a complex, have something to do with flooding, because of us something is not being done, I can understand. That can be we may have to go. But if your case is that we are going to have all these recreational things there, then you are destroying an established thing with proposed things which are also required to be constructed. Viewing tower, cafeteria, boating, cycling, all good. You have enough land there to do that also. But if you are trying to requisition a established, well-settled, well-known tennis complex of a very good standard, then it's a question of substituting one for the other. Does it give that right? Where do you get this right? And how are you forming your opinion? On what basis? That meeting decides on 25-4 and you are passing that order on 25-4 without knowing what the meeting presided over by Chief Minister has decided. Your Lordship has seen. It could not have been imagined. In fact, my lord, when this was prepared for the National Games in 2007, the help that was given by both the then Chief Minister, Mr. Gogoi, late Gogoi, and then concerned minister, now the present Chief Minister, Mr. Sharma, they contributed to the establishment and growth of this complex. I can't imagine him that he is thinking of demolishing this when he is taking those decisions in the meeting on 25-4. It is utilized. It is utilized for a very good public purpose, and it has stood its time. It is not causing any harm to anyone. It is not causing any impediment in any process that the government may like to take with regard to the clearing of the Silsako bill. Nothing, no allegation of that. And the decisions taken in that meeting cannot reasonably stretch to taking of an existing utilized public utility complex, giving an opportunity to the youth to have the best possible coaches, and thereby they have created within 10 people from Assam has gone. Therefore, beloved, in my humble and respectful submission, the power under section 3 is a subjective power. The person exercising that power has to satisfy himself that the condition precedents which are mentioned in the sections are present. And therefore, it is necessary to requisition something. 52. Therefore, my lord, this section itself is in subjective terms. You have to be satisfied that this complex has to go. Why? For these, one of these reasons. If you say it is for flood control and anti-erosion measures, anti-erosion doesn't come in at all. Flood control, urban flooding. Urban flooding means what? Rainwater flooding. For that, the bill water body is already treated. They are saying that it has paid dividends by our accounts. And if that is so, then how will you have the recreational measures which you are contemplating? And is the deputy commissioner aware that he will remove this, but this is going to come here? Is he aware? Does he say that in his affidavit? We are specifically alleging that he has not applied his mind to the relevant facts. He doesn't reply. These decisions are taken on 25th. He passes this order on 25th. How can he be aware of what the decisions are there? Chief Minister is presiding and he has taken these decisions. You go by a circle officer's survey report and say all 19 institutions go. Absolute non-application of mine. And beyond the purpose for which it can be exercised. More so after the affidavit has come indicating what is sought to be done. Without that also, knowing that we have in our petition alleged that whatever you want to do, we are not a contributor to that problem. And we can coexist with whatever action you are proposing or you are trying to do.
We've taken that point.
Yes. There is one case I would like to place with us. Yes, 75 Supreme Court. There are 75 Supreme Court 550 Miller. There's a very well-known judgment on preventive detention, but it has laid down the parameters which have been followed as far as subjective satisfaction is concerned. If satisfied or if the opinion, these are all in subjective terms. Para 9 Miller.
Yes.
But that does not mean that the subjective satisfaction of the detaining authority is wholly immune from judicial reviewability. The courts have, by judicial decision, carved out an area, limited though it be, within which the validity of the subjective satisfaction can yet be subjected to judicial scrutiny. The basic postulate on which the courts have proceeded is that the subjective satisfaction being a condition precedent for the exercise of the power conferred on the executive, the court can always examine whether the requisite satisfaction is arrived at by the authority. If it is not, the condition precedent to the exercise of the power would not be fulfilled, and the exercise of the power would be bad. There are several grounds evolved by judicial decisions for saying that no subjective satisfaction is arrived at by the authority as required under the statute. The simplest case is whether the authority has not applied its mind at all. That's the simplest case, which is the case in our case. The simplest case is where the authority has not applied its mind at all. In such a case, the authority could not possibly be satisfied as regards the fact in respect of which it is required to be satisfied. That's the problem. Emperor versus Sibnath Banerjee, 43 Privy Council 75 at page 90 is a case in point. Then there may be a case where the power is exercised dishonestly or for an improper purpose, which is such a case would be a negative in the existence of satisfaction. The existence of improper purpose, that is a purpose not contemplated by the statute, has been recognized as an independent ground of control in several decided cases. The satisfaction, moreover, must be a satisfaction of the authority itself. And therefore, if in exercising the power, the authority has acted under the dictation of another body, as the Commissioner of Police did in the case of AR 52 Supreme Court 16, and the officer of the Minister of Labor and National Service case 46-2 All England Report so and so, the exercise of the power would be bad, and so also would the exercise of the power be vitiated where the authority has disabled itself from applying its mind to the facts of each individual case by self-created rules of policy or in any other manner. The satisfaction said to have been arrived at but by the authority would also be bad where it is based on the application of a wrong test or the misconstruction of a statute. Where this happens, the satisfaction of the authority would not be in respect of the thing in regard to which it is required to be satisfied. Then again, the satisfaction must be grounded on materials which are of rationally probative value. The grounds on which satisfaction is based must be such as a rational human being can consider connected with the fact in respect of which the satisfaction is to be reached. This is the requirement. If the authority has taken into account, it may even be with the best of intention as a relevant factor, something which it could not properly take into account in deciding whether or not to exercise the power or the manner or extent to which it should be exercised, the exercise of the power would be bad. Pratap Singh Kairan. If there are to be found in the statute expressly or by implication matters which the authority ought to have regard to, then in exercising the power, the authority must have regard to those matters. The authority must call its attention to the matters which it is bound to consider. That's the requirement. It is not a circle officer's recommendation. It is not a joint commissioner of another department's recommendation. There is one more other ground on which the subjective satisfaction reached by an authority can successfully be challenged, and it is of late becoming increasingly important. The genesis of this ground is to be found in the famous words of Lord Halsbury in 1891 AC 173. Then it is quoted. When it is said that something is to be done within the discretion of the authorities, that something is to be done according to the rules of reason and justice, not according to private opinion, according to law and not humor. It is to be not arbitrary, vague, fanciful, but legal and regular. Then it goes on to say how US has gone further, but there is one paragraph next page which I emphasize. But in England and in India, fourth line from top, the court stopped short at merely inquiring whether the grounds on which the authority has reached its subjective satisfaction are such that any reasonable person would possibly arrive at such satisfaction. That's the test. A reasonable man's satisfaction is what is contemplated. If, this is the portion I like to emphasize, if, to use the words of Lord Green in so-and-so Wensbury case, words which have found approval in the House of Lords in so-and-so, the authority has come to a conclusion so unreasonable that no reasonable authority could ever have come to it, then the courts can interfere. In such a case, a legitimate inference may fairly be drawn, either that the authority did not honestly form that view, or that in forming it, he could not have applied his mind to the relevant facts. That's the inference the court will draw. It will be a legitimate inference to draw. That's what it is says.
I'll just
Either
take
he
a,
has.
I'll just take a break and come back.
Yes, yes. That is quite well settled. Therefore, in my respectful submission, Milo, the condition precedent in this case has not been satisfied.
What is the AR citation?
AR
1952,
Supreme Court, page 16, Milo.
15.
16,
16, okay.
Commissioner of Police versus Govardhan Das Bhanji.
Bhanji.
That is a copy.
I will not require. Yes.
Therefore, my lord, in my humble and respectful submission, the condition precedent in this case has not been satisfied. Number one, there has been no independent application of mine. It will be testus and negative. There is one more case below I will cite on this application of mine. Secretary of State for Education and Science versus Kim Sen. This is below
76.
This case is below 1977 appeal cases 1014 and is equal to, my lord, equivalent case 1976 3 All England Report 665. I am getting a copy which is, my lord, in the SCC online true print, and that your lordship will find there the earlier judgments of the courts are first given. If your lordships kindly turn to page 22, at the top, my lord, the paging is given. At page 22, this is the House of Lords judgment, finally. This is judgment of Lord Wilberforce. My lord has got it at page 22, my lord. This is the House of Lords, final judgment, and affirming the Lord Denning's view in Court of Appeal. And I'll not trouble your lordship with too much. This is also about subjective satisfaction. And paragraph 2, my lord, at page 25, I'll be relying on. The section, my lord has got it.
25 years.
The section is framed in a subjective form if the Secretary of State is satisfied. This form of section is quite well known and at first sight might seem to exclude judicial review. Sections in this form may no doubt exclude judicial review on what is or has become a matter of pure judgment. But I do not think that they go further than that. If a judgment requires, before it can be made, the existence of some facts, then although the evaluation of those facts is for the Secretary of State alone, the court must inquire whether those facts exist and have been taken into account, whether the judgment has been made upon a proper self-direction as to those facts. This is what I am relying on. Whether the judgment has been made upon a proper self-direction as to those facts, whether the judgment has not been made upon other facts which ought not to have been taken into account. If these requirements are not met, then the exercise of judgment, however bona fide it may be, becomes capable of challenge. This is, my lord, clearly applicable so far our case is concerned, and so far as the order of the Deputy Commissioner under Section 3 is concerned. He has not applied his mind. We have alleged that he has not denied that fact even. So this proper self-direction as to relevant facts, that is what is needed. And if it is not there, my lord, then the order is vitiated. Oh. So I have submitted with regard to the absence of the condition precedent and non-application of the mind. Because, my lord, it appears from record that the proposed plan was not before him. The plan about which the affidavit talks, about what is to be going to be done there, apart from the flooding and the bill, these recreational activities and all that. This picture, in our humble submission from the record itself, doesn't appear to be present in his mind. At least there is no application of mind to those aspects. Even otherwise, below the application of mind has to be with regard to the conditions set out in the section 3. Even that is not present. And we have said that in our petition, to which he has not replied. Because below that will require a different application of mind. If he had known this, a reasonable man would have said, why are we closing down a tennis complex? What for? If in that situation, if he had known that this is the plan, that there will be some recreational things there, it will be a question of his balancing the public utilities, and second aspect he would have had to think of, can this both coexist? Just as the Delhi laundries, I was giving your lordship the example. The complex is there. You have the lake, you have the walking thing, you have the picnic spots, you have the zoo, everything. All are coexisting. It is possible. Why should this good complex of public importance vanish after all these years? You have contributed public money to its growth. Why should it go off? I can understand the more bigger public purpose which will be achieved, but that is not the case. It can coexist. We have said that in our writ petition at 2 places, and they don't deny that. Paragraph. Coexist, we have said at page 10 and page 14. Both remain unrebutted. So there has been absolutely. He is not aware, I think, about this. It doesn't look like. He is getting that order from the Secretary of the Housing, and he is passing the order on the same day where the decisions. So that is one. Then the condition precedent is not there. And already I have said that the tennis complex is not part of the reservoir. We have already utilized the land, so there is no question. Therefore, my lord, the disclosure in the affidavit about the alternatives, that if that was present in his mind, then the things would have been looked at different. That is not apparently there. And this act is also 2008. And prospective, and our allotments come in 99 and 2003. So in my respectful submission, my lord, and the order is absolutely vitiated. No, that act, 2008 act is prospective. There is no problem.
So we have the Advocate General.
Yes. Deeply aware.
So what I could gather, Lordship, they have basically challenged the impugned order on the basis of 3 grounds, which Lordship will find at page 14 of the writ petition. So I will deal with all these 3 issues which they have raised, Lord. Paragraph 17, the impugned order suffers from inherent defects. Firstly, the condition precedent for exercise of power under section 3 is absent and would vitiate the proceedings being without jurisdiction. And to expand it, they have also said that there is non-application of mind and there was no knowledge to the person who issued it. Secondly, the tennis court in question is a great public interest, and as such, requisition as contemplated is inconceivable in the facts of the case. And thirdly, the complex is in question can coexist with any measures taken for flood control. That apart, no reasonable person could have included the act in question to destroy and fully build tennis complex with the contribution of the government. So these are the grounds they have basically urged in their writ petition and also argued before this honorable court today. If Lordship is pleased to look at page 20 of the writ petition, few vital facts which I would like to place before I make my final submission. I'll try to make myself very concise as possible. Page 20, on 10th of June 1999, with reference to the above, I am directed to say that the governor of Assam is pleased to order for allotment of land measuring 5 bighas in Dag number 602 of Hengarapari. Under Beltola Moja, etc., on the ground of to all Assam Tennis Associations subject to the condition that the land should be utilized for specified period within the period of 3 years. So initially in 1999, 10 June, a plot of land measuring 5 bighas in Dag number 602 was allotted to all Assam Tennis Association for the purpose of construction of a tennis complex. Then Lordship will kindly come to page 30221. So within these 3 years, they could not do anything. So subsequently, there is another allotment order. This was of 4th July 2003. In cancellation of the department's letter dated 2010-2000 and with reference to your letter on the subject cited above, I am directed to say that the governor of Assam is pleased to order allotment of additional Sarkari land 3 bighas, etc. in favor of all Assam Tennis Associations subject to utilization. Till date, the status of the land is allotment. It has not been permanently mutated. Now, Lordship will kindly come to page 22, which is the impugn order. Order issued under Rule 4, subsection 3.1. I will place these relevant rules also at a little bit later, but let me place this. And Lordship will also kindly mark Form B at the top. So they have to finally satisfy this honorable court that whether there is any infirmity in following the law as
Just a moment, this page 21
yes,
is not cancellation of earlier
No.
allotment.
No.
yes.
It is an additional.
In addition.
allotment.
I stand corrected, dear Lordship. So now, page 22, this is the impugned order. At top, Form B, see Rule 4 and Section 3.1. In exercise of the power conferred to me, on me, under Section 3.1 of the Assam Land Acquisition Act 1964 and notification dated 15 July 1993, I, Pallav Gopal Jha, Deputy Commissioner Kamrup, do hereby requisition under Section 3.1 of the Assam Land Acquisition Act 1964, the land described in the schedule below along with the building standing over the land with effect from the date of this order for the purpose of development of Silsaku Bill as a reservoir and facilitate mitigation of urban flooding in pursuance of Department of Housing and Urban Affairs dispute letter dated 3rd March 2023. So here two things which Lordship will mark: the relevant provisions of the rules and the act and Form B format, and also for the purpose of development of Silsaku Bill as a reservoir and facilitate mitigation of urban flooding in pursuance of the department's letter dated 3rd March. So this is which is put to challenge, and it was issued to all Assam Tennis Association and also requested that. Then there is Form C also. This under Rule 5 of Section 3.1, whereas the land described below has been requisitioned under 3.1 of the Act, you are the owner, tenant, person in occupation of the said land are directed to surrender and deliver possession of the requisition land to the collector of Kamrup Metropolitan District, Guwahati, within 15 days from the date of service. So this was issued. The date is not properly indicated here. In any case, it should be. That is not legible. So it's a part of the writ petition, Lordship. So now we have to place before this honorable court what ultimately compelled the deputy commissioner to issue these two notices under Form C and Form B. And before going to that, I would like to place the relevant rules and the provisions of Section 3. One of the major argument is that an opinion has to be formed by the deputy commissioner. This is their main thrust of the argument. And there is lack of that opinion formation on the part of the deputy commissioner who issued the impugned orders. Now let us look at the language of Section 3 of the Assam Land Requisition and Acquisition Act 1964. Section 3, Lordship has got it. 3.1. If in the opinion of the state government, Lordship will kindly mark this, deputy commissioner is not the state government. The department, concerned department is Dohua. They are the state government. So deputy commissioner's opinion is not relevant, not at all required. He is the executing authority. If in the opinion of the state government or any person authorized in this behalf by the state government, it is necessary so to do for maintaining supplies and services essential to the life of the community or providing proper facilities for accommodation, transport, communication, irrigation, flood control. Lordship will kindly mark this, flood control, and anti-erosion measures including embankment and drainage. This drainage is relevant, or for providing land individually or in groups to landless, flood affected or displaced person, or to a society registered under the Assam Cooperative Societies Act, or a company incorporated under the Companies Act, formed for the benefit of rehabilitation of landless, flood affected or displaced person, or to provide land for the purpose of construction of border fencing and allied works, including border roads and checkposts connecting therewith along with Bangladesh border. The state government or the person so authorized, as the case may be, may by order in writing requisition any land and make such further orders as appears to it or to him it is necessary or expedient in connection with the requisition. 2, the subsequent part is not relevant. 3.2. An order under subsection 1 shall be served in the prescribed manner on the owner of the land and where the order relates to land in occupation of a tenant, also on such tenant. When the order for requisition is made by any authority other than the state government, any person interested in the land within 30 days from the date of service of the order may appeal to the state government in such appeal shall be final. So when an order has to be issued under the provisions of land acquisition under Section 3.1, it has to come under 3.2, where it is said an order in subsection shall be served in the prescribed manner on the owner. Now, what is the prescribed manner? That Lordship will kindly find in the Assam Land Requisition and Acquisition Rules 1964. Rules.
Yes.
Now, Lordship will kindly come to Rule 4. An order of requisition under Section 3.1 shall be in Form B, as far as may be, with such modification if any may be necessary. So the impugned order, which is put to challenge here, Lordship, is in Form B. And we have also issued Form C also. That Lordship will kindly go through. Rule 5. An order under subsection 1 of the Act shall be in Form C where the surrender or delivery of possession is to be made to any person other than the collector. The letter shall be issued and order authorizing the person before an order or surrender or delivery of possession is issued. So what we are concerned is Form B and Form C. Now Lordship will kindly come to Form B at in the rules. Lordship will find that in the schedule.
Yes.
Form B says, in exercise of the power conferred on me under section 3(1) of the Assam Land Acquisition and Requisition Act 1964 and notification so and so, I do hereby requisition under section 3(1) of the Assam Land Acquisition, the land described in so and so with effect from the date of this for the purpose of. So purpose has to be indicated here. What is the purpose? If Lordship is pleased to come to that impugn notification,
Okay.
there are two purposes indicated there. The first one is for the purpose of development of Silsaku Bill as a reservoir. That is purpose number 1. And subsequently another word has been used, and facilitate mitigation of urban flooding in pursuance of department's letter dated 3/3/2023. So there are two purposes. And one of the purpose which is given indicated in 3(1) is flood control. So for the purpose of flood control, the land is being acquired. And who has to form the opinion? It is the state government. The deputy commissioner has no role to play. Now, if Lordship is pleased to look at our affidavit, what compelled the deputy commissioner to issue it? There is a letter. If Lordship is pleased to look at that affidavit, which we have filed yesterday at page 36. Annexure A. March 3, 2023, Department of Housing and Urban Development, Government of Assam. This is a part of Government of Assam. The Deputy Commissioner is not considered as Government of Assam under the rules of executive business. Issued by the Joint Secretary to the Government of Assam, Department of Housing and Urban Affairs, Dispur, Guwahati 6, addressed to Deputy Commissioner, Kamrup Metropolitan. Subject eviction operation at Silsaku Bill. With reference to the subject cited above, I am directed to inform you that the details of numbers of structures demolished and the quantum of land freed from encroachment around Silsaku has been submitted by CEO GMDA. It has also been, so one part is Lordship, already the eviction had taken place. Till now, 499 houses were already evacuated and demolished. And today the second round is starting from the afternoon. So till date, 499 households were already removed. Those litigations judgment also I will place before this honor. And there was no relief to them. Secondly, it has also been informed that 17 institutions, organizations were allotted land by the government from time to time. One of them is the Tennis Associations complex. Since clearing of the obstruction to Silsaku is of immense importance, acquiring of the properties allotted by the government and payment of due compensation for the construction is imperative. Hence, you are requested to undertake necessary steps for starting the acquisition proceedings in respect of 17 annexure institutions, organizations as per regulations. These issues with approval of Honorable Chief Minister of Assam. So at the highest level, the opinion was formed and opinion was executed. So forming an opinion of the Deputy Commissioner is not at all relevant, not required at all. The opinion is to be formed as per the Act Section 3. It is of the state government. So there is no doubt about that. All these judgments which my learned senior friend has placed has no relevance. Whether subjective opinion, application of mine, he has nothing to do about that. He is just to comply. And he is authorized under the Act, the Deputy Commissioner. The government cannot directly acquire the land or requisition the land. The procedure is laid down in the 64 Act, as well as the rules framed thereunder, as well as the 1894 Act also. There are two parallel acts, the Central Act as well as the State Act of 1964. And both the acts can coexist. There are Supreme Court judgments as well as Honorable High Court judgments also to that effect. Now coming to next page. We have not singled out this tennis complex to be evacuated, Lordship. Lordship will kindly see the list at page 37. Lordship will kindly see the DUG numbers. All the old DUG numbers are 602. All this up to 17 complexes, Lordship. In the column number 2.
But just a moment, for your last submission, I have a question. This. This form which you showed,
Yes, Lordship.
page 496 and 497.
Form C and Form B, Lordship.
Yes, yes, let me go through the origin first before putting the question.
427 is Form B.
Oh, just a moment.
Mm.
Because here you see, in
The
this
second-
form,
Yes,
secretary is the
yes,
person to give the
Yes.
notice.
yes. He can also do now. The authorization is given to all the deputy commissioners of the state. There is no doubt on that.
Okay,
Yeah, persons authorized under section 3(1). So therefore, Act also says, the rule says, Act provision section 3 says, in the opinion of the state or of any person authorized in this behalf by the state government, all the deputy commissioners are authorized. There is a notification to that effect also.
okay.
If required, Lordship, at 2 o'clock, I can furnish that also. And therefore, the deputy commissioner in his notice also has very clearly says, there is a reference to that letter of 1993. If Lordship, third line of the impugned order at page 22. In exercise of the power conferred on me. Have Lordship got it?
Just,
Yes.
yes,
In exercise of the power conferred on me under section 3(1) of the Assam Land Acquisition Act 1964
okay,
and under notification dated 15 July 1993. I,
Okay.
Pallav Kumar Jha.
okay.
So there is no doubt about the power given to him. They are not questioning the authority, they are questioning the opinion formation. But that also, Lordship, it is very clear. I can produce that notification.
No, not required.
Not required, then it is fine, Lordship. Now, page 37 of my affidavit. Statement of land acquisition proceedings of 17 institutions, organizations of Silsaku Bill of village Hengrabari. Lordship will kindly note all the DAG number 602. There is an importance on that, Lordship. New DAG numbers, different new DAG numbers. Areas, so far as area of allotment to number 1, hotel management, 20 bighas. Present type of patta is all these lands belongs to government. And if for a moment, Lordship, that impugned order, one important thing I've left out, page 22 of the writ petition,
Page.
22 of the writ petition, the impugned order, Lordship. Schedule. DAG number 602. Next, patta number Sarkari. So this land is still in the name of government. These are all government land till date. It was allotted, but they have not mutated in their name. They are not settlement holders. So now page 37, 602 serial number 1, total land 20 bighas, type of patta government. It is allotted in favor of hotel management, and hotel management 20 bighas was given, out of which 4 bighas was given to Ginger Hotel. That was an internal arrangement between Hotel Management Institute and Ginger Hotel. So Ginger Hotel is also going to be removed there from that place. Next is Sahitya Sabha, 50 bighas of land. Next. So we are
Just a minute.
We have not singled out this tennis complex, Lordship.
Yes.
Lordship will kindly see the remark column of serial number 1. Requisition under section 3(1) of the Assam Land Acquisition Act 1964 has been completed. So 3(1), here it is under challenge, but so far as Ginger Hotel and this Hotel Management Institute, it has already been taken over. So completed. Next is Sahitya Sabha, they were allotted 50 bighas. As per report of the circle officer, the concerned land is vacant, hence the issue of requisition does not arise. As per resolution of the special SDLSC, that is Land Advisory Committee, meeting held on 29th April, few days ago, allotment has already been cancelled. So from Sahitya Sabha, allotment is cancelled. Third is Assam Tennis Association, the process is going on.
Completed. Yes.
It is completed, but it is not rightly written. It is under challenge now. If they had handed over, then it would have been completed because this was not prepared today before filing of the case. Then fourth is the State Cooperative Management, the Cooperative Management Institute, 5 bighas, 3(1) report indicated is completed. Then Titabar Bhavan cancelled, 1 bigha. Coach Rajbangshi Sanmilan, 1 bigha, completed. High School Teachers Association, 1 bigha, cancelled. Serial number 7. Omiyo Kumar Institute, this is a very reputed institute, Lordship, for all this research work. It is adjacent to the Ginger Hotel. 2 bighas, requisition under 3(1) has been completed. So Omiyo Kumar Institute, it has great public importance, just like the tennis court complex, Lordship. Then 9th is all Assam Maitri Coordination Parishad, cancelled. Then another is school, Hengrabari High School. Requisition under 3(1) of the Assam has been completed. They were given 6 bighas, 2 lessas, 5 kathas. Next phase, Lordship, 1 bigha to Assam Tea Labour Welfare Council, cancelled. 12, Hengrabari Junior College, 3(1) proceedings going on. So 3 bighas. So 2 educational institutions. Then the next one, 13, National Institute of Film and Television and Theatre. 3(1) is going on, 1 bigha. Then residential complex of officers of Assam Vidhan Sabha, cancelled. Tepuram High School, requisition not required as possession is the other side of the road. These 3, 15, 16, 17, for the time being, we are keeping this in on hold, which Lordship will find little bit later, because the VIP road, these are on the left side. If we go from the 6 mile area towards Narangi, it is on the left side. These 3, 15, 16, and 17, at this stage, the remark is requisition is not required as the possession of the land is on the other side of the road. But this is also not final. If Lordship is come to the next page, page 39. We had a major drive of eviction, Lordship, of the households during the month of February and March. When everything was done, Lordship, then there was an issue that what will happen to those institutions. These 17 institutions were either started their projects or some are in the pipeline, Lordship. Now this meeting held on 25th of April 2023 at Honorable Chief Minister's office at 11:30 regarding Silsaku project and other things. A review meeting of the following projects pertaining to the Department of Housing and Urban Affairs was chaired by the Honorable Chief Minister on 25th April at 11:30. The presentations are Silsaku Bill project and other 5 projects. After threadbare discussion, the following decisions were taken at the meeting regarding Silsaku project. DC Kamrup to initiate the process of taking back allotted land from those public agencies, institutions that have not utilized the land for which the land was allotted. So those who have not started the project, it will be taken back. Those public agencies, institutions that have partially used the land allotted to them or are to be asked to return the unused portion of land in the interest of project implementation, Jirat can be paid in respect of semi-permanent structures that have been erected. So the partially utilization is that Ginger Hotel, where they have utilized 4 bighas, rest were still with the management. They have not done, I think, till now. That project has not completely come out. 3, land acquisition proceedings to be initiated in respect of those who have made permanent structure the tennis association's complex. They have done completely. They would be entitled to only Jirat as the land has not been settled. So they are not settlement holder. We have application of mind is there of the government that it was allotted in 1999 and 2003. Till now, it has not been settled. Government has given them money to start the project. They have also admitted that with government's money, they have started the whole work. Till date, the land status is Sarkari. I have already placed that, Lordship. So they will be entitled to only Jirat, so the project cost, as the land has not been settled. So they are still not a settlement holder. So they do not have lot of rights as under the land regulation, Lordship. 4, land parcels against which Miyadi Pattas have been issued, if falling within the project area, are to be acquired. GMDA will provide specific information to the DC Kamrup Metro about the properties out of the settled land that are essential for the projects to be completed. Upon such receipt, DC Kamrup Metro will acquire the land through issue of notice as per the process of law. There is a case that Purbansal Construction, a land was allotted to them, I think in 1997-98, and it was settled and premium was also taken. From 2008, they are trying to get the building permission. GMDA has refused. The litigation is continuing. Yesterday also it came for hearing. They paid a total amount of 25 lakhs as a premium. Now, in case of those situations, Lordship, the proper acquiring will be done and the compensation will have to be paid. So that Purbansal housing complex will never take place. The deputy commissioner's report, the drone photograph, all these coordinates are given. The same plot of land during summer, it is all inundated with water. During winter months, it is all dry. So these are allotted. So lot of things have been done at the behest of the state also. The land should not have been allotted or settled at any point of time. The mistake was committed by the state government's officials at one point of time. But that cannot be a reason that why we cannot bring it back to the original position. That from the report I'll place a little bit later, Lordship. Now, this is number 4. 5. All such institutions with whom land was settled or to whom the land was allotted initially, but who have subsequently been allotted by the state government elsewhere, like Army, School of Nursing, other state government institutions, may be approached for reversion of such land to government by DC through the use of Istafa agreement. 6. GMDA will prepare a list of encroachers whose land parcels are located within the ROW, that is right of way, of the project plan in the first phase, and DC Kamrup Metro will take action to remove such encroachers expeditiously. Then number 7, institutions in possession of land on the left side of VIP roads towards Narangi from 6 Mile should not be disturbed now. The Lordship will kindly mark that word now. That's serial number 16, 17, and 15. We are not touching them at this moment because it is on the left side of the road. If it is required, then road will have to be diverted also. So for the time being, we are keeping that part on hold, but that is not final. So therefore, this conscious decision-making process, very rightly minuted, that institution in possession of land on the left side of VIP road towards Narangi from 6 Mile should not be disturbed now. These land parcels are not to be included in the discussion in future presentations. For the time being, it is all kept in hold. if the project finally says that that part is also required, then they will discuss. A revised plan of action to be prepared based on the decisions taken today. This plan will be discussed at the next meeting on Silsak on 15 March. Some of this could not take place on 15 March. Last about 10 days ago, but it is on the pipeline. Now, this is the decision which was taken, and thereafter, Lordship, this process was initiated. This is a basically a review meeting. Now, whether this tennis complex can coexist. We are not doing this whimsically. The state, after a lot of efforts, lot of investment and lot of time, Lordship, has come to this conclusion that a proper project should be done for mitigating the artificial flood problem in the city of Guwahati. Sometime 3-4 years ago, Lordship, the GMDA was entrusted to find out certain projects by which, Lordship, the problem of artificial flooding can be checked or arrested. If a international tender was floated, Lordship, seeking the expertise of various organizations of the world who can give us a project. Initially in 2012 also, one Israeli company did the complete mapping of Guwahati, including the hill encroachment, etc., where there is large scale of erosion. So that Tahal group of Israel gave one report, and subsequently for this artificial flooding, we have floated another international bidding, Lordship, and one Australian firm, it is named Alluvium. They have given us the final project report on 11th of October 2022, last year. So I have 3 copies, but this I'll take back after the hearing. I'll give one to them also. I do not want these things to be discussed in public. So 3 copies I have prepared, one for Lordship, one for the other side also, because I'll place certain things. It is not a whimsical decision that the government has taken to remove these 500 families from a plot of land where they are enjoying for decades. And also that what is in our plan. Lordship will kindly take this. The relevant portion we have already quoted in our affidavit, but I'd like to place it from the DPR.
Mr. Saikia, if you otherwise don't want this to be part of record, then don't place it, because you see, we can't prevent.
No,
things
Lordship can
from-
quote it. No, because if I give it to the other side and if it is gone to the media and there will be a
No, that's
public
right.
debate on this, I
No.
do not want that.
No, that's why, you see, how,
Now,
how,
I can make all my submissions without looking at this also.
no, that's okay, but
But
then
To
take it
give
back.
authenticity,
No, we take it from you once an
then
advocate
Lordship
general
may keep
making
it
a
also. Then
submission,
Lordship, it can be a part of the court's record.
because you see, you know the difficulties.
No,
Now-
what in our affidavit, what I have said, Lordship will kindly note it also. In our affidavit, I have said, because there are a lot of experts in the
No,
market.
no, it's
Lordship.
okay, but.
Lot of experts and lot of second opinions,
No,
third
no, that is
opinions.
okay, but
And
you know, in the court,
ultimately,
there can't be any secret.
yeah, no, we are not keeping our secret. If they are so conscious, they could have asked it through RTI.
No, 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 not that. You see, we are not questioning
No.
what Mr. Goswami will say or do. What we are on is
No,
that
once
if
it
you have,
goes
if the
out,
state,
Lordship, there will be lot of debate because these are,
no, we can, as a, you see, as a,
everybody has a vested interest. If I have a plot of land, I would have also seen it from a different eye.
no, not that. What I'm trying to say is that, Mr. Saikia, that as an advocate general, as an officer, the law officer of the state, you can make a statement, we'll record that. We need not need this as a
No.
proof of your statement, but
I understand, Lordship.
mm,
I fully bow down to this observation of the honorable court, but in our affidavit also we have said,
we'll take that. Because if you don't want this to be a, it's a public debate.
I do not want a public debate because
No, because you see, Mr. Saikia, I'll be very candid about it. You see-
let us be frank, Lordship,
You
let
see,
it be a part of the record.
You see, the reason is that the document which you are producing in court
Yes,
will not be a personal property of Mr. Goswami.
no,
So
what I am saying,
therefore-
Lordship, once it
No,
becomes, then there will be lot of experts' opinions,
You can
not
give
from
a-
the lawyers.
you can give a gist of it. instead of giving a document,
We have given a gist in our affidavit.
then it's
Here
okay.
also page 34.
then it's okay.
Page
because
34.
Then we'll not keep it as a
The
record.
deponent craves leaves of the honorable court to place the DPR of the above mentioned at the time of hearing and also to file a detailed affidavit if required.
It's okay.
So we
Uh,
have
you know,
already indicated that there is a DPR.
If you have some anxiety, because
That-
these are
because I-
reports will have.
No, I have anxiety is not on the other thing. The
Many
anxiety is
ramifications.
if a project is been taken, it is going in the right turnings. And if there are a lot of debates on this now, whether alluvium is rightly doing it, not doing it, why this is there, why that is not there.
I
We
know,
have
I
no shortage of expert opinions in
I
the
know,
market.
I don't deny your statement.
Tomorrow, this honorable high court will be taken to some other place. There will be a lot of opinions. Whether it should go to Boragaon, whether it should go to Rangmahal, whether it should remain here, whether it should go to Rupnagar. Everybody will have their opinion. And if that happens, Lordship, no decision can be ultimately implemented. At certain stage, Lordship, we have to be a little bit undemocratic also.
Discreet is the right word,
Uh,
not undemocratic. And the government can't be undemocratic.
Because everybody's opinion
It
cannot
can
be
be discreet.
entertained. I am saying using that word because everybody has a right to give opinion, but
Because it's
all
a
the opinions
democratic-
cannot be accepted.
Because a democratic government, your government can't say it is undemocratic. It can be discreet.
So Lordship will kindly take this, the first page.
Yeah.
Comprehensive DPR for rejuvenation, remediation and sustainable conservation of Silsaku Bill. Final detailed project report, volume 1, 11th October. Alluvium is the party. Then Lordship will kindly come. Executive summary. Page 1.
Because these reports are merely reports, just a short statement. You see, at one point of time, the medical fraternity came together and formulated that a particular level would be the high blood pressure level. Correct. And then debates were on, and now the what you call United Nations, and now they have come out with the health. WHO has come out that a blood pressure level is different, and they have made a statement that this was manipulated by medical companies to increase the volume of sales. So you see, because reports are merely reports.
Yes. And that is one part. Here, when we started constructing the new medical colleges, a wide level of media opinion was formulated that what is the use of so many medical colleges when there will be less doctors? There will be no doctors to manage. So there was an agenda of a certain section of the doctors through various media houses that we should stop all those construction of the new medical colleges. Now from 2008, there are 391 seats. Today we are having about 9 or 10 colleges and 1,500 MBBS doctors are coming out every year. If we had accepted the opinion given in by those doctor fraternities, that additional medical college would not have come.
Yeah, right.
So there are always difficulties, but the thing is that we have to take a firm decision and follow it. May I read it, Lordship? That because this will give a gist of what exactly we are going to do and what is the necessity of having this DPR and this project.
Before you show us this, just a statement, this report has been accepted by the government.
We are implementing it, Lordship.
Okay.
We are implementing it.
Then there is no secrecy about it.
Yes.
Executive summary. Silsaku is a significant wetland on the eastern part of first urbanizing metropolitan Guwahati. Although the wetland has legal protection under Guwahati Water Bodies Preservation and Conservation Act 2008 and other directions of the Honorable Green Tribunal, it has remained vulnerable. And I'm just saying, during while I have hearing the other side's argument, I received 7 number of approvals, the financial approval, which amount to about 100 crores. This whole project is of 250 crores. The administrative approval, it is in my WhatsApp now. The concerned chairman has just forwarded me that things are still progressing. Things are going on, Lordship. Work has started. Although the wetland has legal protection under Guwahati Water Bodies Preservation and Conservation Act 2008,
This is it, turn to page 1.
page number 1. And the other directions of the Honorable Green Tribunal, it has remained vulnerable to the threats typical of any urban area, namely urban encroachment, untreated water waste inflows. The bill area has thus shrunk considerably and its water quality has deteriorated significantly. In 2015, excavation commenced in the largely marshy riparian area of the east of the bill, partly to protect the area from encroachment and partly to create a major flood moderation reservoir. At the same time, a bypass channel was created to trap the wastewater flow from to the various drains and discharge the same to the downstream north side of the bill. The northerly discharge empties into the Brahmaputra River, and as such, NGT stepped in directing the treatment of wastewater presently discharging into the Brahmaputra untreated. Hydrologically, the bill receives a homogeneous amount of surface runoff from its 15 square meter catchment area. This surface runoff is laden with silt, has reduced the retention capacity of the bill and is causing frequent flash flood in the neighborhood area. Guwahati Metropolitan Development Authority has initiated excavation in an area approximately 3 lakh square meters. The initiation taken has shown prominent result during the last flood season. The project called for addressing several complex issues. Excavation of the bill area to increase retention capacity of the bill to at least 35 lakhs cubic meter to reduce the flash flood in the surrounding area. Treating the wastewater inflow to ensure standard compliant discharge of Honorable NGT order to Brahmaputra. Ensuring that the excavated area has perennial water spread and shall act as a groundwater recharge zone to have sponge city effect. Retaining the biodiversity element of the bill, recovering encroached land from the bill channels, creating urban green and blue public area with recreational elements. The project is thus a combination of 3 interlinked features: original bill channel around 3,000 meters long, the excavated lake of 5,000 square meters spread, the bypass channel to sewer to the southeast north area of the bill, 1,400 meters long. The project plans to include nature-based biomedication, etc. These are the various things they want to do. Next page, Lordship. Now, coming to page 6. Present status of Silsaku Bill. Project understanding. I am reading 3.2. Present status of Silsaku Bill. Shallow wetland in Assam are locally known as Bill. The Silsaku lies between so and so longitude. The Bill used to be surrounded by Amsang Wildlife Sanctuary in the east, VIP Road and Sachal in the west, Narangi in the north and Panjamari in the south. In 1912, the total area of Silsaku Bill was around 1,758.47 square hectares or 17.58 square meter. The Bill runs south to north on the eastern outskirts of Guwahati city, surrounded by villages at Satgaon, Hengrabari, Modgoria, an area which is first urbanizing. Silsaku Bill is spread over a 1,000 square feet of land as per the revenue records. However, with encroachment, the size of bill is now significantly reduced. Notified areas of Silsaku Bill as per Guwahati Water Bodies Conservation Area has been mapped in GIS format by GMD and Assam Science and Technology Environment Aztec. As per report, there is no existence of physical demarcation of the water body and it is enclosed in several places. Pausing here for a moment, Lordship. That act, I'd like to place that act. That act is a part of this here also. It will be page 83. Yes, if Lordship is pleased to. What is that from? 6032%. Yes, the internal page will be 86. The act started page 83, and Lordship will kindly come to the schedule number 3, Silsaku Bill. So Silsaku Bill, have Lordship got it? Schedule of land, District Moja Revenue Circle, all lands, Doug number, Hengrabari. (602) Doug number is there, Lordship. And all these 17 institutions have their original Doug number as 602. I have placed that chart, Lordship, page 37. The fault lies with the government officials because in 1999, 1996, 2003, these bill areas should not have been allotted at all. But these are curable mistakes. The officers who were at the helm of affairs in revenue department or the district administration, they would have taken into consideration that 602 cannot be allotted to anybody. But so many institutions, including Sahitya Sabha, Lordship, the Hotel Management Institution, Amiya Kumar Das Institution. So 602, it is not that in 2008, all of a sudden 602 was inserted in the area of Khilkhakul. If you look at the history, 1912 also says the area. So I paused at one point. Yes. Again, I'm coming back to page 6.
Yes.
As per report, there is no existing physical demarcation water body as is enclosed at several places. They have reference of 2008 also. The siltation that has occurred has reduced the retention capacity of the lake, which act as a reservoir for stormwater of the city. This water body wetland ecosystem is seasonally flooded with stormwater runoff from the surrounding hilly terrain. A sluice gate and pumping station at the Bondajan river prevents black flow from the Brahmaputra river. The total population residing on either side of the bill is approximately 392,000, and the water consumption stands as 52 MLD as per GMDA POR. Khilkhakul bill provides a natural settings with an emergent urban edge. Ecologically, it is of great significance as an area supported with different food chains and food webs, recharging groundwater, and is habitat to significant biodiversity having ecological and economic value. It has the potential to become the active recreational facility in the city while leveraging the natural settings to address the water storm management system. These recreational facilities, those boatings and all, Lordship. The threat factor noted in section 1.2 are clearly in operation in the Silsaku basin and can easily be observed. The fact that the area of bill remains non-demarcated is itself a cause of vulnerability for the wetland. If conservation action is further delayed, the bill could well disappear under layers of infrastructure and buildings. Hence, the present initiative is timely. They have realized that already concrete has taken over this bill. We have Ginger Hotel, we have Amiya Institute, we have all these constructions. So this is the last time we can recover it, Lordship. So hence the present initiative is timely. In the light of modern town planning concept, the bill can play a very significant role in meeting the sustainable development goal, and provide the entire spectrum of ecosystem services to the eastern part of the town and collaterally raising the quality of life and land values in this part of the metropolis. Also, considering the pattern of extreme rainfall events, the conservation of the bill is essential to moderate local flooding. Presently, Silsaku bill catchment area is densely populated with nearly no vacant land for additional population or facilities within the basin area. The bill is primarily non-perennial in nature. However, during monsoon season, the combined sewerage and stormwater flows through the bill, which also receives dry weather untreated sewerage inflow throughout the year. A major city drains carrying combined sewerage has been constructed recently, diverting a portion of the flow of Bahini River, which runs through the city into the Silsaku bill. Moreover, a major drain carrying combined sewerage and stormwater from Meghalaya hill catchment has its outfall into the Silsaku bill. Apart from these two, many minor drainages carrying sewerage and storm water currently outfall into the bill. Now the excavation work, Lordship, would kindly see the photo here. Work is
Yes.
already going on. Next page also photographs, next 2-3 pages. Now, Lordship will kindly come to page 10. This is very interesting, and this was already taken notice by the another honorable court of this honorable judge of this honorable court, which I'll place, Lordship. Changing cartographic profile of Silsaco Bill 3.4. Lordship will see how big the Silsaco Bill was in 2003 when this tennis complex was yet to be started because land was being allotted. Lordship will see the demarcation. How big was the bill? Then in 2013, it was narrowing. The next page, Silsaco in 2015. And finally, in 2021, it more or less resembles a small portion and there is a long drain. How we are killing this eco-friendly water body in the midst of the city. Page 12 is the Silsaco Bill of 2021. So it will resemble a drain now if you do not take any corrective measures. So now, page 14, issues and objectives. 3.5 is issues, 3.6 is objective. The following issues could be identified so far. The extended area of the bill now has been significantly excavated to prevent further encroachment and to act as a flood moderation basin. However, the bed profile needs to be further modified for hosting biodiversity. There are significant inflows of untreated wastewater and sewerage resulting in widespread hyacinth cover and maybe have to be diverted or treated before admission into the bill, extended bill. The riparian littoral areas of the bill are enclosed even as the precise area of the bill remains unsolved. Thus far, the geometric modification of the excavation profile of the extended area bed, banks and shoreline needs to be established to ensure conformity with the requirement of structural safety, biodiversity, habitat, and uses of the public. The hydrological aspect of the basin needs to be studied to ensure that the bill has a reasonable perennial water spread. This cannot be sustained on rainfall alone and may require inflow of adequately treated wastewater to fill up the extended bill and therefore neutralizes losses. The bill basin suffers from substantial soil erosion and copious rainfall brings in large quantity of sediment along with the surface runoff. The substantial part of the basin lies with the state of Meghalaya and cooperation of that state would be prerequisite to address the issue. This issue, if not addressed, can change the sectional profile by raising the bed level of rapidly reducing the storage capacity. The role of the bill as a public urban space and urban biodiversity habitat needs to be defined to play its role in providing ecosystem services as well as setting up revenue streams for meeting the O&M cost, operation and management cost. Objectives: ensuring a healthy lake ecosystem. The bill is there, Lordship, but we finally want to make it a big lake so that the reservoir, there is ample water throughout the year, not only depending on the rain. Ensuring a healthy lake ecosystem with perennial water spread and clean outflow to Brahmaputra River. There is direction from the NGT that our discharge to the river is all polluted. So we have to have a STP at the mouth. So which project is going also. Yesterday, another PL we are facing that in Bhorolu also, whether we can have a STP in the Bhorolumukh area, where the river discharges to the river, Brahmaputra.
That is most essential now.
Yes, it is very much essential. A PL, and we are agreeing, Lordship. We are not taking all this public interest litigation as an adversarial litigation, Lordship. 2, flooding,
But
improve.
that plus there's a lot of bad odor now coming up.
Yes, Lordship.
And there's that in Delhi also there's what do you call that?
Jamuna.
Yamuna. So that those what do you call
STPs.
no that white slush all
Yes,
around
yes,
the
yes, Lordship. Yes.
in what do you call I don't know the right word. White slush you find in the Baralimuk is there in that Jamuna
Yamuna at
one point of time.
and lots of there's a big project taken for cleaning the Ganga, Lordship. That has already taking place. The
You
Ganga.
continue
But-
to,
Yes, Lordship.
you were to go out.
I have cancelled it while sitting here. I'll go either tomorrow morning or this evening. I had the flight at 12 in 2 o'clock, Lordship. So I have to leave at 11:30. I stopped that. This is greater public interest. Deeply offensive.
And if time permits, my lord, at least after, before rising, my case may be taken, I think 46 months. Because it is fixed for entry mode. Congratulations.
Yes.
May please. I'm continuing with the DPR, Lordship. If Lordship is pleased to come to 9.2 at page 51.
Yes.
In fact, every part of this DPR is very relevant. I'm just pointing out which are relevant from the perspective of the case, Lordship. 9.2, sustaining the lake and the bill. The lake water level will be built over a period of 2 to 3 years using direct precipitation and treated wastewater. The sequence of events will unfold as follows. On completion of excavations, sluice gates, pumping arrangement, biomedication treatment plan system, direct rainfall will accumulate in the first monsoon season. From August, the southern and eastern inflow will be admitted through sluice gate at northern end of the lake from bypass channel to build up the lake to 6 meters in the first year. The approximate inflow is about 3.6 MCM, whereas the lake capacity is approximately 1.0 MCM after excavation. Subsequently, evaporation losses will mount, but the lake will still have at least 4.5 m of water depth till before the next monsoon. In the next year, the exercise will be repeated only in September to build up the water depth to up to 6 m, supplementing the direct rainfall impact of 0.6 mm of July, August, September. The sediment will settle, leaving clear water. The lake can then withstand annual evaporation loss, which are about equal to the annual rainfall, and maintain its water content as there is no percolation losses. If required, an appropriate amount of treated wastewater flow would be pumped into the lake at northern end of for the period of 4 months, November to February, to neutralize evaporation losses. Mostly the treated wastewater would flow through the bill. And various processes are here. Then page 54, rejuvenation of the bill. Lakes are intrinsic part of the ecosystem. A lake or pond is the water body which holds certain volume of water generally in all seasons of the year. Lake have traditionally served the function of meeting water requirement of the people for drinking, household uses, for washing, agriculture, etc. Apart from these functions, these involve direct use of the lake water. Lakes are also known as recharge groundwater, channelized water flow to prevent waterlogging and flooding. Lakes are also host to wide variety of flora and fauna. Increase in water scarcity at one instance and flooding conditions at the other instance emphasizes the importance of revival and rejuvenation of water bodies. This is the ultimate objective, Lordship. Then next page, the lake rejuvenation program. I'm not going to the detail. These are the various technical issues which are dealt with by this report. Then Lordship will kindly see the Water Bodies Act and the map. Water Bodies Act, I have already placed it. Water Bodies Act, the preamble part, Lordship, I would like to place at 283. Guwahati Water Bodies Preservation and Conservation Act, 2008. An act to provide for preservation, protection, conservation, regulation, and maintenance of water bodies, and to develop the water bodies into natural water reservoirs and convert into ecotourism recreational center to suit the ecological balance within the jurisdiction of Guwahati Metropolitan Development Authority and to protect the water bodies from the encroachers and damages. So this preamble very clearly indicates what exactly is the purpose of this act. Whereas it is expedient to provide for preservation, protection, conservation, regulation, and maintenance of water bodies, and to develop the water bodies into natural water reservoir and convert into ecotourism recreational center to suit the ecological balance within the jurisdiction of Guwahati Metropolitan Development Authority, and to protect the water bodies from the encroachers and damages and matters connected thereto and incidental thereto. So my humble submission is that this act also emphasizes the requirement of recreation, but that recreation does not mean that tennis has to be there or a cricket has to be there. That recreational part things will be related to the water games. The boating is there in Dighali Pukhuri. That is a part of the ecosystem. That will not harm the overall situation. If there is a water body, what is the harm of using it for aquatic sports? So that part is already indicated and enclosed in the original act. And therefore, my humble submission is that this present action on the part of the government through Deputy Commissioner and GMDA is not a knee-jerk reaction. All of a sudden, it has not been done. It was a part of the 2008 Act itself. It is a different story that the government was sitting idle. Now the government has become proactive. The act is already there. 602 is already there in 2008. The government ought to have cleared all those dark numbers. If they have not done it, now it is being done, and there is no challenge to this act till date. First, they have to challenge why 602 is inserted in the scheduled plot of land. We have a legal backing now. The statutory backing is there. This act itself provides that the water bodies of Guwahati must be protected. And if there is any infirmity, if it is unconstitutional, it is creating problem to some institutions, first action would be that they have to challenge it to make this act ultra vires. If the act is already there, Schedule 3 is very clear, the various DAG number 530, 531, 532, etc., and 602, the original DAG number. And all these institutions are part of this 602 original DAG number. So government has wrongly allotted this land. There are some beneficiaries and there are some persons who are responsible of doing it. A water body land has been allotted. Why it has not been settled till now? The things would have come out. That is why there is no effort on the part of the beneficiaries to get it mutated in their name. So somehow they managed to get 605, 602 plot number and 5 bighas and 3 bighas, whatever the area. So the project has started. Government was also part of the wrong thing. Government is a continuous process. Who is running the government? That is not important. The government ought to have protected its citizen and its biological diversity. It is a sovereign duty of the government. And therefore, this honorable court has said, land acquisition is a part of the sovereign duty of the state. In Tarini Deka's case, Lordship, the judgment was of 2 days ago, 22nd of February. When the Deputy Commissioner, Kamrup Rural, wanted to acquire a plot of land in Amingaon area, Lordship, for the purpose of setting up of a transport terminal for Numaligarh refinery. These are all patta lands, some are not patta lands. And in that case, Lordship, an observation has been made at paragraph 27, internal page 63. Paragraph 27, a process of requisition or acquisition which is undertaken by the state in exercise of its sovereign power has got very little scope for being challenged, and such challenge can be sustained only if there is a violation of the statutory provision. In case of a construction of a road, for an example, Lordship, I have my village, I have my ancestral property. The government wants to widen the road, make it a 4-lane. Lot of houses have to be vacated, and it was finally demolished and land was acquired by the government. everybody can come out here, excuse that if the road is diverted little bit, my house can be protected. Everybody will have that kind of a excuse. Will that ultimately help the government to construct that road? Because somebody's paternal property will be touched at one point of time. Recently, a project has been undertaken to widen this Mirja Road, make it a 4-lane. Lot of families came to North Guwahati's deputy commissioner that our family's ancestral property will be touched. If you divert it through another 50 meters or 100 meters, everything will be protected. Ultimately, all these requests were turned down. So public interest will prevail, and there are two legislations where the interest of the landholders, settlement holders are protected. They will get adequate compensation, 4 times the market value under 2013. So now they are saying that 5 crores were invested for that development of the tennis property. The government has taken a decision that as the land belongs to government, no amount will be given for the land, but for the Jirat, that means the properties, it will be adequately compensated. Now, their efforts should have been, Lordship, now. I'm not advising them to approach the government and find an alternative plot of land somewhere else. With that money, they can immediately in 2 years' time or 1 year's time, another property can come up. But that is not the case here. The case is that they want to challenge. So let us face this challenge face to face, head to head. So now, when the Honorable Court says a process of requisition or acquisition which is undertaken by the state in exercise of its sovereign power has got very little scope for being challenged, and such challenge can be sustained only if there is a violation of the statutory provisions. So what statutory provision we have violated? According to them, they have 3 grounds. One ground is that opinion was not formed. I have already placed the opinion of the state government is required. The opinion of the deputy commissioner is never contemplated in the act itself. The other 2 cases are on factual part. Before proceeding further, Lordship, I would like to place this map. Page 90 of the DPR.
Page 90.
Detailed topographical map with contour of Silsaku bill, March 2022. So this is the actual bill, and major portion is under encroachment. Number 1 is encroachment, and some are legitimate constructions also, but that allotment was not actually permissible under the Act of 2008, or earlier also, when the Act was not there, when it is a bill land, it should not have been done. Bill has not been created in terms of 2008 Act. The bill was in existence for more than a century, because this report also indicates that Silsaku bill was there in 1912. It is not, our Dighali Pukhuri was 400-500 years old. So my humble submission is that we have to restore it, the Silsaku bill. And for that, 500 families already evicted.
You are showing me this page 90
Page
For-
90.
for what
This,
purpose?
this is the actual map, Lordship. Detailed topographical map with contours of Silsaku bill, March 2020. This project report finally said this is the, and the contour, depth, etc. are all described here. Different soils at page 95. The 95 is very interesting. Filled up soil from EGL. I do not know the full meaning of EGL, but that means earth filling has taken place in the bill. Grace, clay. These are soil testing reports. So how we have killed a water body in the heart of the city. This is a crime actually, Lordship, in my humble submission. In the same judgment, no, so I'm on a different judgment now. I'll place another judgment. When we have conducted the eviction drive of the illegal encroachers are always illegal, so encroachers from Silsaku area, series of litigations came up before the Honorable Guwahati High Court. WPC 1156 of 2023, Rup Jyoti Bora and 9 others. There are series of cases, Lordship. If Lordship is pleased to come to that page number 14. Series of cases. I am skipping from, we have not enclosed page 2 to page 13. There are series of litigations, repetitions, Lordship, batches of cases. So second page is straightway from page 1 to page 14. From 14 to 29 is a judgment. The writ petitions, writ judicial court has been sought to invoke by these 5 writ petitions which have been filed with similar cause of action. In the first writ petition, by order and interim order protection was granted and direct matter to be listed on 3.3. 2 subsequent matters moved on so and so for analogous hearing of the motion stage with earlier writ petitions. Further, it was observed that if the eviction was not yet to be done, the same may not be carried out till the next date, that is 3.3. Today, apart from aforesaid writ petitions, 2 more writ petitions have been listed in motion number so and so. The principal challenge in all these writ petitions is against the action of eviction of the petitioners. In the deliberation which commenced, so and so clarified that at the outset his argument is based on the points of law and therefore no affidavit in opposition is required to be filed. In that stage of the matter, the writ petition are taken up for disposal at the motion stage. 4. The petitioner so and so 3 in number claim to be occupying small plot of government land in village Hangrabari Mouja of district Dispur Revenue Circle. They claim to have constructed residential houses and have been allotted municipal holding numbers by the concerned authorities. The petitioners also claim to have been given electricity connection. The petitioners claim that they are in occupation of the land since last 12 years and the land neither reserved for any government department, road or public purpose, nor the part of the wetland of Hilhaku freshwater lake. So at least the Honorable Court observed it is a lake. Petitioner identical narration is there. Paragraph 9. It is the common cause of the petitioners that on 26/2 and 28/2 at around noon, a large contingent of police force along with officials of GMDA and GMC came to the land of the petitioners with bulldozers and JCBs for the purpose of evicting them and demolishing their dwelling houses. It is in the aforesaid cause of action, aforesaid cause for which the instant writ petitions have been filed. So there are submissions. Now coming to paragraph 46. All these judgments relied upon arguments from both sides, from our side as well as their. Paragraph 25. The learned so and so clarifies that the eviction drive is not restricted to the action to be taken only under the Water Bodies Act of 2008 alone, and the same is also a general one under Regulation 1886. It is submitted that Rule 18.2 and 18.3 of the settlement rules under the said regulations are distinct and different. Rule 18.2 is with regard to eviction from certain categories of land, including khas land, water bodies, and grazing land, etc. Whereas 18.3 is for the land not covered under 18.2, and the statute requires serving of notice only when 18.3 is involved. He submits that admittedly the land in the instant case is either khas land or land which the boundaries of water bodies is clear from the schedule of Water Bodies Act. 26. The learned AG further submits that the present action is one of which the immense public interest is involved. It is submitted that maximum 200 families residing in the said area may be affected by the eviction drive, whereas such an eviction drive would benefit the entire city of Guwahati, which consists of more than 7 lakhs families. Pausing here, at that moment, 200 families. Now it is today, it is 499 families we have already evacuated from that area. It is submitted that the petitioner and other persons in that locality have encroached upon the government land and the water bodies have been filled up with rampant manner, which is a major cause of artificial flood in the city of Guwahati. The so-and-so has strenuously argued on aspect of prejudice by not serving notice before the eviction drive. Without prejudice to his contention that notice is not necessary, the learned AG has submitted that since the facts are admitted and the land in question is khas land and the status of petitioners are mere encroachers, no explanation whatsoever can be put forward by the petitioner which can be held to be convincing. Now coming to the finding of the court. Paragraph 46. This code This court may take judicial notice of the fact that the artificial floods have almost become a routine in this city of paragraph 46, Lordship, internal page 28. This court may take judicial notice of the fact that artificial flood have almost become a routine in this city of Guwahati, where after a heavy shower, the entire city is inundated and reduction of water bodies in Guwahati is one of the main reasons for the same. As indicated above, satellite pictures of different periods placed before this court would readily indicate a shocking state of affairs wherein a huge water body has been turned almost to a drain. I have placed 3 photographs today also from the DPR. The other day it was all 3 separate photographs. 2003, 2015 and 2022. The said satellite picture 3 numbers are made part of the record. While dismissing this writ petition, this court is also of the view that, as stated by Learned Advocate General of the state, the present eviction drive may be set an example for initiating such drives to clear all water bodies, especially in and around Guwahati, including the Deepor Bill. Illegal encroachment in the hills in and around Guwahati is also to be made encroachment free with stricter steps against cutting of the hills and deforestation. In view of the aforesaid facts and circumstances, this court is of the considered opinion that present may not be a fit case for interference, as much greater goal involving public interest is being sought to be achieved, wherein this court has not noticed any apparent aberration of law. In view of the same, the writ petitioners are dismissed. In that case, we did not issue notice also. Here we are issuing notice because it is their allottees. The earlier was their direct encroachers of the government land. So 18.2 indicates a lot of judgments of this honorable court says that notice is not required. At this stage, now we become little bit lenient at that point of time. At this stage, this court has also given thought to the individual hardships of serious nature. We have considered on that day, Lordship. Though specific pleadings are not there in the petition, it has been submitted that the wards and children of some petitioners in the locality are having their annual examinations, including HSLC and higher secondary class 12 examination. This court has also indicated that hardship may also be in the form of some petitioners who are suffering from serious ailments and are not able to shift immediately. For those cases, liberty is given to the petitioners to individually approach the authorities in question by submitting written representations with supporting documents with an undertaking to vacate the encroached land on or before 10th of April. And if such steps is taken within 15/3/2023, the same may be considered and a reasonable time may be granted to vacate the land under their possession. This liberty, however, cannot be extended for an indefinite period. So we consider that taking of the humanitarian angle, Lordship. But here it is a tennis academy. So we have other tennis facilities in Guwahati. If this 350, which I doubt, 300 players are going there. There are several other facilities available. One belongs to the government at Dispur, Rudra Singha complex. My Lord Justice P.G. Agarwala is one of the person who is involved with that project, where the government has given that to their organizations for conducting the tennis practices and all. It belongs to Director of Sports and Youth. There are other facilities also available in Guwahati, one in Nehru Stadium also. If they are so keen for development of game of tennis, Lordship, we have no difficulty. That arrangement they can apply and they can get it to continue their practice till the time a new facility comes up under their initiative. Beyond that, we cannot commit anything. Everything is taken care of by the law in force, 2013 Act. If the Jirat has to be compensated, it will go as per the law. They cannot be given any special treatment. In fact, in the same area, 58 bighas of land was given to Assam Cricket Association in 1998. Same area. Somehow ACA did not take that land. Allotment till date has not been cancelled. Personally speaking, in 2019, when I became the secretary, I wanted to get back that land. I went to that area to find out where is that 58 bighas. The persons who sold out and who were at the helm of affairs of 1998, They could not trace out that land there. Everything is encroached. That 58 bigha land went missing. It is a very deplorable plight. I do not know why that point of time that 58 bigha land was given to Assam Cricket Association. They have got the same thing. They have capitalized it. Somehow ACA did not capitalize it, maybe for good reasons on a hindsight. So some officials of the revenue department or the district administration who may have no love for the city, who could think of that allotting these water bodies to sports activities. Not only sports, and now Sahitya Sabha office is there, Amiya Kumar Das Institute is there, hotel management is there, 2 educational institutions are there, one college, one high school. So this ought not to have been done. We are killing our own city. We have to sacrifice at some point of time for the greater interest of the city, so that the people can live, the next generation can live in peace. This honorable court took so much a matter regarding the encroachment in Amsang. 50% we have evacuated. We have cleared. Rest 50% still hanging on. The litigation is still continuing regarding the demarcation and all. Some revenue places, some forest land. So that dispute is now delaying. But when my Lord Justice Ajit Singh as Chief Justice was here and when that division bench was taking, we cleared 997 number of households, but remaining 1,000 still remain. And now we are hearing that people are again coming, but it is a part of litigation now. So government is also a little bit apprehensive of removing those things at this stage, until and unless the survey, Geological Survey of India gives the proper demarcation. So the facts are very clear that it is not a knee-jerk reaction or all of a sudden we have started this process. This process was going on from records from the statute itself of 2008 that Silsako is to be protected. All the lands in the schedule area belongs to Silsako bill. Whoever may be occupying that are illegal encroachers from the perspective of that particular statute, whether it is a tennis court or whether it is a Sahitya Sabha office. Ginger Hotel, they also may have 150 employees. We are closing that also. We are closing that running business. 499 families till now have been forcefully evacuated from that area. If Lordship has to give relief to them, then Lordship ought to have given relief to the other parties also. Because in that case, it is not playing tennis. It was their livelihood, their regular living. Tennis does not come under, or sports does not come under in that category of shelter, food, and livelihood. So we are touching livelihood. We are touching the shelter, and we are touching the life of the students and the ailing people there. So everybody is making alternative arrangement. So this particular institution, writ petitioner also have to make alternatives arrangement if they want to continue their tennis. So 3 grounds, Lordship, that all 3 grounds, Lordship, in my humble submission are not tenable at all. Paragraph 17. First is that condition precedent for excess of power under section 3 is absent. In my humble submission, it is present. The state of Assam has expressed in very clear terms, without any ambiguity, that the state government wants to protect and mitigate the water body and mitigate the flooding problem in Guwahati. All the documents which I have produced before this, the Chief Minister's meeting, the other one is that letter of Dohua, 3/3/2023. And on top of that, their whole contention that the Deputy Commissioner must make up his mind. He must have subjective satisfaction. That, in my humble submission, is not contemplated under section 3(1) of the 1964 Act. Second ground, tennis court is of great public interest. Yes, I do agree it has a public interest, but it has a great public interest according to their pleadings. But the greater public interest is the problem facing by the citizens of Guwahati. Citizens of Guwahati do not have an alternative. These 300 players and few officials, they have an alternative arrangement. They can go and pick any other tennis courts in Guwahati to continue with their tennis activities. On top of that, they can create another tennis facilities from the compensation they are going to get. But another water body we cannot create. We cannot create another water body in Turunnagar or in Bhangagar. We have to stick to Silsapu, Bundajan, and the other water bodies which are still alive in our city. Third is a complex in the questionnaire can coexist. Lordship may not go into this aspect because the expert body which we have entrusted through a global tender system, they are the experts. Neither the petitioner nor we are experts. So we have hired, and therefore whatever project report they have given, it has been adopted and it is in the process of implementation. There can be a lot of opinion. That is why I said that I do not want to part with this. The reason being that there are a lot of other experts who can have different opinion and which is genuine. They can be also right. They may be totally wrong. But we have to stick to a one plan of action. So this coexist concept, Lordship, otherwise not a single road is possible in the country. Everybody will have a reason not to part with their ancestral property or their own property. So in that view of these three grounds, Lordship, are not tenable. If they can find out any further grounds, if they argue, then I'll give my reply. Otherwise, this writ petition is liable to be dismissed. Deeply obliged.
Yes, Mr. Goswami, anything in reply?
Yes. I'll briefly indicate here. This is not a litigation concerning what steps should be taken to eliminate the problem of flood, urban flooding due to rains.
Lordship, may I take leave? Lordship, my colleague will be here.
This litigation is not for that purpose. I have a very limited prayer and very limited answer. It is all right. You are floating a global tender. You are getting the views. And you are proposing to act on that. Problem is, all of us are residents of Guwahati. We know what is happening on ground. We want an end to this. There is no doubt about that. So that is not the subject matter of this litigation. We want the water bodies to be preserved. There is no problem on that score. You yourself have given allotment to us to open a complex. You have spent your public money for partly constructing the complex, namely the courts and everything. So you can't take a stand now that it was wrongly done. That is not an answer in law. Now, my lord, we want also that this water body should be protected. It is not a case of illegal, unauthorized occupation. The encroacher's case and this case, you cannot compare.
Is directly obstructing.
The encroachers were evicted because they had no right. Their presence was causing problem in drinking the water body. That's why the eviction. That's why this court said, you have no right, you have to go. As far as this is concerned, your allotment itself is there. You have financially helped this organization and had the 2007 National Games played there.
This is not cancelled yet.
You have not cancelled that. It has become a reality. It exists for the last so many years now, from 99 onwards. 2008, this act has come. Assuming everything said, Has any provision been pointed out from 2008 Act that whatever was done prior to this will become null and void? No. It's a prospective act. The act says that. Therefore, 2008 is not a bar. And what is our case? We are not opposed. We want also a Guwahati without flooding. Well, I remember seeing a discussion in TV, local TVs, some years back. It appears, well, the state government first asked the got it from the Assam Engineering College. One professor who looked into the matter and he was present. Secondly, they submitted a report. Then again, government went to IIT, Guwahati. And that professor was also available. And he said that we studied the problem, we submitted a report. So 2 reports from 2 institutes are there, possible. They have said that on TV. Then the anchor was asking her what happened. He said that we were asked to give a report. We said that it can be tackled and we suggested the methods. After that, we can't keep on asking what have you done. If they have not done, not done. But apparently now we have become international. So first Israel, I am told. Secondly, now Australian. Report is before your lordship. So all this is good. I am not decrying anything. It is good if we can solve this problem. Only thing is this. Has any paragraph been shown to your lordship saying that this kind of a complex is causing the problem? I am talking about the report. Nothing. They have also not said. What did they say? You can have eco-friendly recreational facilities. That's what they have said in the affidavit before your lordship. So, if it is an eco-friendly facility which can be created and their own affidavit says what is going to be done, including a tower for viewing,
Jogging and cycling.
cafeteria,
Jogging, cycling.
jogging, cycling, boating.
Aquatic sports, that is not.
This is not aquatic sports altogether. Boating is, but not the others. What is your case then? What am I saying? All that I am saying is your affidavit itself indicates that what you are proposing to do, one of them is eco-friendly recreational activity. Has your deputy commissioner considered that fact and balanced it with the existence of a tennis complex? Is it not an eco-friendly recreational activity?
For pensioner to qualize, it is obstructing.
It is. Has the report been mentioned even impliedly that this kind of a tennis complex is bad? How could they? Because they are recommending eco-friendly recreational facility for this area. And that is exactly what I am trying to project before your lordship. That if you are going to exercise this power, then is it not reasonable to expect that the deputy commissioner also takes note of the project and says that eco-friendly recreational facility is permissible? Would he not compare, balance it out, whether to requisition, which is already in existence for the last so many years, and which is of public interest because we are having our youngsters being coached. That's in itself is a public interest matter. I am not stopping the preservation of the water body. I am not saying that there should not be eviction from unauthorized occupant. I am not an unauthorized occupant.
Belek bill was-
You have constructed a stadium, cricket stadium. Very good. It is good. That is also part of 2008 Act,
portfolio.
Borsala Bill, one of the scheduled water bodies. So we have to go ahead. It's not that life stops. 100 years ago, it was the body. We need the bodies, water bodies. For that, whatever is recommended, go ahead. We are not objecting to that. Our case is very, very limited. Your own documents show that you will have this kind of things. If you are having these kind of things, why throw out something which is already in existence of the same nature? It is a recreational activity.
You can allow public also.
Question is, have you considered that? I am surprised that it is argued that under Section 3, this is a government of Assam's order. I don't think it deserves an answer, but since it has been argued with such force, your lordships kindly have a look at the provision itself. Section 3. And the order itself says how he is exercising that power. There are two ways or two authorities under this Section 3 who can look into the matter, form the opinion, and take the action. One is the state government. Or, this is the second person, or any person authorized in this behalf by the state government, and that is his opinion. If in the opinion of the state government, that is number one, if the state government decides to pass the order of requisition, or any person authorized in this behalf by the state government, it is necessary so to do. Therefore, the impugn order itself says that I am being authorized by this notification of 1993 by the state, and I am exercising the power under Section 3. Therefore, it is absolutely meaningless and incorrect to submit that it's a government of Assam's order. Explicitly, the order doesn't say that. It's an order by the Deputy Commissioner on being satisfied as required. Whether that satisfaction is real, whether that satisfaction is after considering all the relevant facts, is the question before your lordship. Nothing beyond that. We are not against your efforts to improve the position of the city. It is welcome. But here is a case where something which is in existence, which is in accord with what you have said or got from the experts' report, that a recreational facility, eco-friendly recreational facilities could be placed there. If that is the objective, if there is no problem with that, would the Deputy Commissioner, while passing an order, not think about it? He is referring to that report verbatim. It is almost quoted without quotation. Whatever has been read out to your lordship. It is there, part of the affidavit. And once you place that document, you can ask that, look, it will be not given to the public. It is public record now. And you will recall the judgment of Justice Chandrachud.
No, this is already a
Yes.
court of record.
Court record.
It's a
How
court of
can that
record.
be argued like that? That you take back this thing again. No, you can't. You have given it to the court, I am entitled to have a look at it. That is what that ADM Jabalpur case, Chandrasud judgment last but one or a few paragraphs. He said that you can't have a situation where the court will look into a document and the petitioner's side will not be allowed to look into it. That's unthinkable in a legal proceeding to argue that.
In fact, that is why I have a
Your
difficulty.
lordship rightly reacted.
I have a difficulty in having, because this is what I always tell. Because when certain reports come in, records come in, then the petitioner's lawyer would not know what will be hitting them. Unless it's a part of an affidavit, it's very difficult to accept a report and then,
If you don't part, if you produce before court, the other side is entitled. That's what Justice Chandrasud in that case said, last but one paragraph. But, and that is what is the problem which the present Chief Justice Chandrasud mentioned some time back, which is reflected that the age of seal cover is over. He said that in that Indian Express lecture. So I am on
Was
a
it
very
very-
short point, you know. If the deputy commissioner had compared and said that for these reasons, this recreation center or this tennis complex is creating a problem for implementation of whatever is recommended by experts, I would not have bothered your lordship at all. But I have placed the entire affidavit for that reason only, taking your time, that there is nothing said about this complex in the entire affidavit that it is causing a problem. Instead, what they are saying is that we are going to have it, eco-friendly activities, sports activities.
Our position for emergent purposes, not for this.
Therefore, my lord, this power is a special power.
Maintaining
Emergent causes are there, therefore this power is used in the public interest.
maintaining-
Therefore, ultimate question is not how to tackle this problem. Ultimate question in this petition is whether what is supposed to be your aim also, namely a eco-friendly recreational sports facility existing with public money also being placed before it for the last 13, 15 years, doing a very good job for the young students or young boys to come up, should be removed from the scene and new facilities, new recreational facilities be created. If the deputy commissioner had this comparison done, he should have said that in the affidavit. He has not done. We have said that there is no application of mine of the deputy commissioner to the relevant facts. He is accepting that in the affidavit. He is not denying.
Anything that
Therefore, this comparison of equal,
that point we have already noted.
oh, yes. So that is what my respectful submission is. That
Was it because,
and this water body act also is prospective. You know. It doesn't say that all that whatever was done is a nullity. That provision is not there. It is prospective.
402
Section 4 also says that, you know, your lordship must have noticed.
that you had already
That your
mentioned
lordship
earlier.
has seen After,
For the first day also you had mentioned.
yes, inshallah. After coming in the force of the act, this will not be. But what will happen to the earlier thing, there is nothing. So that is one. And then, my lord, the encroachers case is slightly different. It has nothing to do with this. And thirdly, my lord, there is no allegation. That is most crucial.
That I've noted.
And lack of application of mind to the relevant facts. That's all.
Close it. Okay? Mr. P.P. Goswami, Learned Senior Counsel.
And he is virtually acting on the direction of that letter, nothing else.
Assisted by Mr. B.P. Boral and Counsel to the Petitioner. Also Mr. D. Saikal and Advocate General. Assisted by Mr. Arbor Pujari, Standing Counsel for Revenue Department. Mr. P. Nayak, Learned Standing Counsel for GMDA, and Mr. C.K.S. Barwa, Learned Government Advocate appearing for Deputy Commissioner. Argument is concluded. Judgment reserved.
Deeply obliged. I'm
This will-
sorry to my,
This will take some time because
yes, there's no problem.
I don't even have a free Saturday and Sunday.
I know, it's very difficult. And
I was just thinking when I was taking my lunch that the live transmission should not be of the court proceedings. It should be otherwise of the daily routine life. So that
very true.
some
It's a
people
very
get,
difficult job. Can you well imagine?
so that's why at times,
We argue and just go away, forget it. Your
That is why
problem
at
starts
times-
after that.
that is why at times we miss that case.
Yes, deeply obliged. And I am very sorry for my colleagues.
In fact, that is why it required us to deliberate and have this tiffin time extended. Because in 45 minutes, I hardly get 10 minutes time for my food. So many files to sign, every day orders to be checked.
And
Okay.
I express my regret to my friends that we had taken so
It's
much
okay,
time.
we have to do
It's
something.
Part of
Okay.
occupational hazard sometimes. Deeply.
Yes, item 2.
Item number 2, almost done.
In this matter, we'll have to issue notice. You already,
Your
notice
lordship,
was not issued, but there was a direction to call for the,
lordship. That your lordship, first day, your lordship, that application was your lordship granted, your lordship, by the district magistrate, your lordship. My
no, that is okay, but formal notice was not issued. You have that report?
Yes, my lord, that report has come. Order is passed. Copy is not very legible, I'm sorry, my lord.
In fact, your lordship, prison manual as well as the prison act, your lordship. Under these two, your lordship, statutory provisions, your lordship, the district magistrate has even has no role to play, your lordship. It is the superintendent of police, your lordship.
Pardon me?
Lordship, so far as your lordship is taking up your lordship WPT 2681, your lordship.
Yes, yes, 2681.
Now, your lordship, pursuant to the observations made by this honorable court on earlier order, your lordship. In earlier order, your lordship, the district magistrate granted permission, your lordship. Thereafter, again, your lordship, for taking the signatures in the, your lordship, in the Falatnama, as well as your lordship, for filing of the representation, your lordship, under National Security Act, your lordship. We sought permissions, your lordship, and probably at the, your lordship, we have applied, your lordship, on 23rd, your lordship. But till yesterday, they did not pass any order, but probably at the
Because if
intervention.
you see, if the time period lags, then
I-
even if 15 days have crossed by, then again he becomes entitled to suo moto release.
I spoke to the officer, district magistrate today in fact. Malad, that will be, they're doing it. Malad.
Time limitation is how much? 15 days.
By today, it will be done. Malad.
Your lordship,
They have submitted a
they have granted me permission, your lordship. Now the problem is this, your lordship, if I have to, your
Malad,
lordship,
order has been passed on 19th of
wait
May.
for your lordship 2 days, 3 days, your lordship, meet with the lawyer have to, your lordship, wait for 2 days, 3 days, your lordship, to meet the client, your lordship, in jail. That is, your lordship, if your lordship go to the prison manual, your lordship will find that your lordship, there is specific provision, your lordship.
The lawyer can't be prevented from meeting the
Yes, that's the
detainee.
They are delaying it, your lordship.
So the lordship, already they have passed an order, allow the lawyer and the mother to meet. A representation has been already given for signature. That will be done today. And lordship may mention in the order that twice.
He was detained when? By order dated?
your lordship, he is
Detained on 3rd of May.
3rd of May, your lordship.
Hello, May. So more than 15 days have already crossed.
Yes, your lordship.
Well, then we'd have to direct his release.
Well, the 15 days confirmation lordship by the government, lordship is
No, at least you see, at least if you deny them a chance of representation, that itself becomes what you call a reason to set aside. Why this fetters in taking a signature and submitting a representation? It itself shows that the detention would be illegal.
no, I'm told that the representation has been submitted on 20.
No, your lordship,
23rd.
what we prayed, your lordship, before the district magistrate, that since we need to submit representation, grant us permission to meet the lawyer, since on the instruction of my client, we have prepared it and he will submit it. But they have delayed it, your lordship, by 2 or 3 days, your lordship, in granting permission. That's the problem, your lordship. And today, probably, your lordship, few minutes back, your lordship, at the intervention of the learned senior government advocate, your lordship, the district magistrate passed an order allowing the council to meet the detainee, your lordship. Now we will come, your lordship, in fact, your lordship, because of these delays, your lordship, my right to representation has been got delayed, your lordship. That will ultimately will benefit me. That's a different matter, but that's
You
my
have
right.
to amend your petition,
No,
incorporate
your
that.
lordship, what I will do, your lordship, I'm going to file a petition, your lordship, habeas corpus petition, your lordship. That's why we need the signature. of-
This writ petition, lordship only.
This writ
the
petition,
prayer-
your lordship,
prayer
will-
is that he should be the.
No, you see, because you see, when it's a national detention under the Prevention Detention Act,
Lordship.
court will always have power to more release.
Correct, but page 13, lordship will
But
find.
for everything, if detainee has to come to court to meet lawyer, to meet a family member, that would be illegal.
No, but that has been allowed. That has been allowed, and the lawyer and the family member, they are free. They will meet. They will be allowed. But I spoke to them. They said that if for NSA detainees and the unlawful prevention act cases, there is a system. Or they said that some permission from the district magistrate is required because law and order problem may arise sometimes. Ultimately, that has been allowed, and they are allowed. And the lordship may record in the order
For
that
visitation, you have a deputy commissioners, it is required.
The
I don't think so.
district magistrate, they
It
used
is
to
not
do,
required,
they used
your
to do something. I
Yeah, in Guwahati, you have a police commissioner.
Yes.
The powers of a district magistrate is taken away.
no district
No, it is in
magistrate
Sivsagar,
because
your
the
Oh, Sivsagar.
detention is
Now,
detention
your
order
lordship
is
go
passed by
through
the
the
district.
Just one. It's in Sivsagar.
It is
Sivsagar.
from Sivsagar.
Oh, acha.
not commissioner of.
Just give us Assam Police Bangalore.
And the district magistrate is the detaining authority. He has detained.
If your lordship go through the judgment, your lordship, in 1981, 1 SCC 608, your lordship,
Yes.
the apex code is very specific that the district magistrate has no role to play. It is the superintendent.
That's what I
superintendent-
understand, but I don't know the law, it is in 1981, 1 SCC.
Yes,
Just pass
1981, 1
pass that
SCC
book.
608.
pass that book. That is why that is what I had in mind, but I did not know the citation. Which paragraph?
Para 11, your lordship. This is obviously cause great hardship and inconvenience because the legal advisor would have to apply to the district magistrate Delhi well in advance, and then also at the time fixed by the district magistrate Delhi maybe not be suitable to the legal advisor who would ordinarily be a daily practitioner. In that event, from a practical point of view, the rights to consult legal advisor would be rendered illegally. Even if your lordship district magistrate is your lordship, exercise that power, we don't have any objection. Subject to the conditions that Let the exercises power, your lordship, expeditiously, your lordship.
This appointment should be given by the superintendent without any avoidable delay.
Lordship. And in fact,
So
your
make it clear that if he seeks an audience, it will be the superintendent of the jail who will give that permission. In this case, we will provide that. It will be qua this order, this case, but if they want to meet, it will be the superintendent of the district jail who will give that permission. So we close this matter.
lordship.
For this, as Thakur, learned counsel for the petitioner, and Mr. D. Nath, learned senior government advocate appearing for the state. Next para. By filing this writ petition under this copy is already here. By filing this writ petition on Article 226 of the Constitution of India, for the who is what is the name of the detainee?
Also here, your lordship.
Page 25, right?
Page 2. Page 25, the details.
Page 25, last paragraph, first line.
Okay. The petitioner who is
Mother of the
who is the mother
mother of the detainee.
of Sri Shrinkhal, SHRINKHAL Saliha, who is a detainee under the National Security Act. And was taken in custody on 3/5/2023. Is praying for a direction to the respondent authorities to direct, so as to direct the district magistrate Sivsagar to allow the petitioner to meet her son and or their legal counsel or any of their close relative full stop. The background facts relating to the arrest and detention of the son of the petitioner is not essential for the nature of relief which has been sought for. And accordingly, the same has not been adverted to. Next para. At the outset, the learned senior government advocate has produced a copy of order number SVMJ/NSA/16/2023/64 dated 19/5/2023 and has submitted that the said authority has already allowed the counsel of the petitioner, the counsel of the family member of the petitioner to visit the district jail Sivsagar to meet the detainee. Next one.
And council and the mother also. allowed, the
My
petitioner.
family member that I've said.
Lordship.
uh, in this regard, it would be relevant to quote paragraph one C and 8 to 12 of the case of Francis Coralie Mullin versus Administrator, comma, Union Territory of Delhi and others, comma, within bracket 1981, like it was 1 SCC 608. Stop. In view of the categorical observation of the Supreme Court of India in paragraph 11 and 12 quoted above, comma, insofar as the present petition is concerned, the present petition and the detainee in, namely so and so, that give that name, so and so Chalia is concerned, comma, the court is inclined to observe that it would not be necessary for the petitioner to approach the district magistrate for an order to meet her son along with her counsel. And it would be appropriate that such an appointment be given by the Superintendent of District Jail Sivsagar and if required, any jail official, comma, if necessary, comma, may watch the interview without being present in the hearing distance of the detainee and the lawyer. Full stop. It is clarified that this order is qua the present petition and the present and the detainee, namely so and so only. Full stop. Next paragraph. As the district magistrate Sivsagar has already given, already allowed the petitioner and the engaged, the family members and the engaged counsel of the detainee to meet him, comma. This petition has served its purpose and therefore there will be no point keeping it alive, and accordingly this petition stands closed.
Yes, deeply obliged.
The the petitioner is permitted to produce a certified copy of this order before the district, with superintendent of district jail, Sivsagar.
Lordship.
Obliged.
Paragraph 11 only, there is an indication that they may regulate it because they may regulate it. May
No,
not
that
be
is why I have already also stated that
may not be
in terms of 11 and 12,
11. Lordship.
in terms of 11 and 12, that I have noted. That's why I said it can be regulated.
Lordship.
Or just in that, if necessary, watch, there you can add, or regulate it as
No.
allowed in para 11
Lordship.
of the above quoted order.
Lordship.
Obliged.
3,
Let me know.
You, Mr. Nath, you will remember that order. Time limits are given,
Yes,
various time limits are given. I think you'll have to
correct.
inform the authorities.
The confirmation has been given by the government.
No, whatever be, but the timelines you know about that
Timeline.
in the previous
Correct.
order.
Obliged.
Yes.
Pertaining to non-issuance of Aadhaar card, at least take notice to this.
Okay. Heard Mr. A.H. Amar Khan, sorry, Chaudhary, then counsel for the petitioner. And Mr.
D Decca on behalf of B Decca CGC.
B. Dega. Appearing on behalf of Mr.
Mr. B Decca,
B. Dega, CGC. For the,
1, 2, 3, 4.
for respondent numbers 1, 2, 3, and 4.
5
And Ms. M. Burman and the government advocate appearing for respondent number 5. Issue notice of motion returnable in 4 weeks. In 1 month, say, medical, 1 requisite extra copies of the writ petition with certain limits, state and CEC in course of the day. Next para, the pendency of this writ petition shall not be a bar for the respondent authorities to examine the claim of the petitioner for Aadhaar card and to issue Aadhaar enrollment card if there is no other impediment for the same. Next para. List after 4 weeks.
Obliged.
But you tell them this thing should not be delayed. Why for 4 times somebody has to apply for an Aadhaar card?
Obliged.
You admitted that the physical copy is not served. But then we can't give a stay.
What's it? The clauses is not the mandatory requirement, dear Lordship. You may kindly find at page 29. The clause where it's stipulated for submission of hard copy of the technical video. Plus 2.13.2. Lordship, got that? May I read, Lordship?
It's addition, that's why it says it is an addition.
Yes.
An addition means it's an addition. Supposing I issue a notice, I say in addition to notice, you also serve by Dasti. You can't come up and say that no, Dasti was not required, it's not mandatory.
But here in this case, your Lordship, from the clauses, appears apparent that there is a procedural requirement. It can be waived, your Lordship, and have to,
That's why we are issuing a notice, whether they can waive or not.
in the
But-
meantime, Lordship,
We will not state. For your own fault, we can't stay the procurement proceedings.
otherwise, your Lordship, in the meantime, if they.
In fact, at page number
finalize
29, your
the-
Lordship.
then
Then
become-
after a few years, we'll tell you that you can approach the civil court for compensation.
Your Lordship.
No, but if it's your fault, if you don't give it, then we can't stay the tender proceedings.
No,
Now you know what is what is the law in that regard.
It's even the Honorable Supreme Court also stated that if the.
But we can't decide that without hearing them.
Yes. So In the meantime, your lordship,
I'll give my reasons for not giving it.
Lordship, just one aspect, page number 29. Clause 2.13.2 may also be perhaps considered, your lordship.
2.13.2,
It's
that is what I said, addition to.
Yes, yes, my learned friend was reading from page number 34, so I just thought I could point that out as well.
Page,
Page 33 is the, 34 is only the evaluation criteria.
thirty-four, which page, which,
2.23.1.
or is this specific of being cancelled? And time for submission of hard copy so and so shall be cancelled. Okay.
Lordship.
Let me say H of the counsel for the petitioner. And Mr. K. V. Pathak, learned standing counsel for the forest department, appearing for all the respondents. You should notice a motion returnable in 4 weeks. You don't need 4 weeks, you can give a shorter time, 3 weeks. Requisite extra copies of the writ petition be served on the learned departmental counsel in course of the day. Next para, heard both sides on the prayer for interim relief. Next para. The case of the petitioner is that he had participated in a tender process for supplying of ration feed materials for zoo captives under Group C within bracket grocery to Assam State Zoo, Guwahati for a period of 1 year. Full stop. It is the admitted case of the petitioner that he had inadvertently omitted to submit physical copy of all the documents required to be appended to the bid. However, it is submitted by the learned counsel for the petitioner that digital copies of all the tender documents were submitted along with the bid submitted, e-bid submitted by the petitioner. Full stop. It is also submitted that the clauses of the bid document indicate that for the purpose of evaluation, digitally signed documents would be referred, the non-furnishing of physical copy of the documents was not a material defect. Next para. It is observed that in clause 2.23.1 of the tender document, it's called a tender document.
Tender document.
The tender document, amongst others, it is provided that the bidders were required to cross-check or confirm whether the bidders have that the authorities would cross-check first to confirm whether all the bidders had submitted the hard copy of the technical bid. And it was provided that if the bidders who failed to submit hard copy of the technical bid within the due date and time for submission of hard copy, comma, the bid shall be cancelled and excluded from further evaluation. Full stop. It also appears from clause 2.13.2 that in addition to submission of online submission of bid, comma, the bidder must submit only the hard copy of the technical bid within the due date and time of submissions as mentioned in the, what is BDS?
Bid data sheet.
Bid,
Bid data sheets.
as a bid data sheet within bracket BDS for short. For short. According to the court, of the prima facie opinion that as the petitioner did not comply with the requirement of the bidding document, comma, the same as disentitled the petitioner to any interim relief at this stage, and accordingly the prayer for interim relief is refused. Next list after 3 weeks. I just will add the tender in question shall be subject to outcome of the rate petitions.
Available.
I,
5. The same matter as yesterday,
Yes.
5 and
Question
13
number-
are same, my lord.
5 and
5,
15.
12, 13, 15.
just write
16,
item 5, 12.
13, 15, 16, 18 and 20.
You have a previous order, copy of previous order.
Yes, order.
We have a writ petition.
Earlier
number-
repetition number 2773/23, my lord, listed on
Same order.
22nd of May, my lord, similar.
Okay, 22nd May, same order.
6,
Same contractor bill. Okay. Item number 6, 6, 11,
17,
17,
19 and 22
19,
and 22.
Lordship,
22.
Lordship, in item 6, 19 and 17, 90% fund has been released by the department also to the contractor.
But some money remains.
Yes.
So that will be examined and same order. Your earlier rate petition number? Where you got the earlier order?
Yeah, yes, Wednesday.
Item number? You search it out and give it to the court master, otherwise your matters will be deferred. You find that, do that exercise and come, tell it to him. But otherwise it will be deferred. I don't have time today to search. If you want me to search, then I will not do it. Yes. Same order.
7,
I will give it now.
But it's page 22, you lost tendency, man. Page 22.
I've seen that, and I have formed a prima facie opinion that if there's a boundary, the dispute between the co-patadars or neighbors,
Neighbors, man.
correct? So it
Huh?
won't be a nuisance within the meaning of 133 CRPC.
That is also if I nothing, man. Police come to come, they are not doing anything and he's continuing. Almost he's going to minor.
But how can 133 apply? 133 is, you see, is,
That also we have annex also, man.
no,
The same authority, man, SDO.
but what is the purpose of 133?
Minor, now what can this party can do, minor?
One yellow kindly see one.
You'll have to encroach my field.
But now nobody is doing anything, madam. I have gone to CEO, the everything.
No, that is why I'm
SDO,
saying
DC.
you'll have to enter my field. My field is civil court.
Yeah, but sometime we are trying to learn it. madam. Now what they're doing, madam, even one
No, but
second.
you know, any public place, it won't be a private land. In
No,
private
but-
land, 133 can't be
Madam,
done.
bylaw is there, madam, that will comply with those here. The report is very clear, madam. We have submitted a submit application, it was gone into, madam, inspection was given by assistant engineer.
That would be illegal.
Yeah.
Under one, if your application is under 133, they could not
No,
have.
no, initially I have filed that, madam, before the deputy commissioner. It was, madam, that inquiry was made by assistant engineer. But just page 22, madam, okay.
Page
Just
22.
page 20. It is madam, STO is writing the chief executive engineer, madam, because it falls under the local bodies, madam.
Where is the building permission which you want to assail? Where is that?
I'm not permission, I'm saying he's he's in the construction beyond that bylaws. And that was that's why it was gone into the assistant engineer. He submitted the report to the assistant executive engineer. Assistant engineer submitted to the SBO.
Where is the report?
This is the report is annexed, you'll also find page 20, page 20.
20.
20. From assistant engineer to the assistant executive engineer. With reference to my application. My application complaint is page 17.
Okay, heard Mr. H.R. Chaudhary and Senior Counsel, assisted by Mr. E.H. M.R. Chaudhary, Counsel for the petitioner.
His name is longer than my name.
Yes,
His name is longer than my name.
okay.
I was under impression my name is longer than mine.
M. Burman and the government advocate appearing for respondent number 1 and 2. So 1, you are there. Mrs. G. Hazarika for 1.
2, 4, 5, and 6, madam.
Burman is, Mrs.
6,
Burman
7.
is 2, 4,
5,
5,
7.
7. This video will be, you will be there. Mr. S. Datta for
3, 6, and 8.
3, 6, and 8.
Panchayat.
Next para. By filing this repression on Article 226 of the Constitution of India, the petitioner has prayed for a direction to the
Official response.
official respondents to restrain the private respondent numbers 9, 10, and 11 from carrying out construction of a multi-story building
At
at
Kabaitari Daily Market.
Kabaitari, K-A-B-A-I-T-A-R-Y, Daily Market in the district of Bangaigaon. Next, it is projected that on as the construction was being carried out in contravention to the Assam Unified
Yes.
Building Construction Bylaws, 2022, the petitioner had made a complaint before the authorities,
Page 17, man.
and thereafter a report was prepared by the assistant engineer, PWD on 15/3/2023 and forwarded the same to the assistant executive engineer, PWD. It is projected that they said report indicates that the construction is in violation of the bylaws.
Page 21, man.
Accordingly, I don't know. It is submitted that Despite this said report, the authorities are not taking an action. And therefore, this writ petition. The notice of motion returnable in 4 weeks. Requisite extra copy, notice and including notice on prayer for interim relief, returnable in 4 weeks. Requisite extra copies of the writ petition to 1 to 8. And steps by post on 9, 10, and 11. List on so and so.
Only my in the meantime, only problem is my I am also aware my limitation so far interim is concerned. The CEO and SPO has informed the CEO. CEO informed the police also might. Nobody is doing anything on it, and they are
Okay,
continuing.
the pendency of the writ petition shall not be barred for the competent authorities
Right.
to take appropriate steps.
What can it
As
be
per the-
positive order
as per
madam,
the-
to the SDO? To
as
see
per
that
the
my
report- As per the report of the report of the
the report of the assistant engineer,
assistant engineer,
yes,
PWD, dated 15/3/2023.
which was forwarded by SDO to the CEO and CEO forwarded to
I'm
the,
not saying all that.
yes.
It will not be a bar. You'll provide certificate copy to whom?
Certificate, the main part is this CEO and SDO and CEO and
Okay.
police officer might.
Petitioner is committed to produce a certificate copy of this order before the circle officer. Concerned.
No, Sakula madam, it will be number 4, 4, 5, 4,
No, no,
5 and
no,
7.
no. It will go in the hierarchy. If you give to number 4, then he will take a step.
SDO. He is the this is a subdivision
He-
area, man.
He is the head
Head
of
of
the
the
subdivision. So SDO, subdivision officer,
Civil North Salmaga away.
civil, North Salma Abhepuri.
Right.
Because he will give a direction.
Yes.
Yes, item 8.
Out of 8, 9, that's those,
Oh, APDCL,
sorry, 8 and 10, man.
8 and 10.
8, 10 and supplement minus 77, 78.
Okay, just give that earlier order you have.
Yes. Your losses order is.
Okay, just a moment. Sorry, just write that case serial numbers.
Oh, serial number, okay. Serial number is minus 8 and 8, 10, 77 and 78. Supplement.
You'll be appearing the matter.
Malaj.
You're there earlier also.
Malaj, I was there.
You was there. Okay.
Only question about the 1st May is the date of termination line.
1/6.
Sorry, 1.
We have given a date. All these matters are given on a date.
No,
There
your
are
worship is just
similar matters fixed on
considered
Monday,
in terms of the one of the order, in terms of status was given, my lord. So your lordship mentioned in your lordship's order, my lord.
So what is the date I have posted all these matters?
All the, yes,
On
today,
Monday,
my
my
lord. So, some matters came, some matters did not come.
There are
Okay.
similar matters fixed on Monday, Malaj, as item number 50 and 51.
Monday we will not be able to take it
Only
up.
today, your lordship is all the
Huh?
matters.
It will become infructuous when?
It will be effective from 1st June.
So 31st we can fix, 31.
Yeah.
Because I don't unlimited matters.
That's why we also, we understand. Can it be
Even
fact-
on Monday, there is a parted matter which is coming up, that will also take time.
Is it possible on 30, my lord? Possible. No?
30
Yeah,
again,
this
parted
one.
matters are there. You can take a chance, but you'll have to wait.
But those 8 matters, one matter will do, my lord. Those 8 matters, all are similar.
30?
Only one matter will do, my lord.
Okay.
Obliged to us.
One of the matters will fix it on 30, others will be 31.
Yes, one will do, my lord. The rest will follow.
Okay. Yes. Who is in item 9? Yes.
My lord, my prayer is very simple and specific.
I'll only issue a notice. There shall not be a bar. I'll only issue a notice. Mr. L.K. Boral and counsel for the petitioner. Ms. G.S. Zarikal and government, the standing counsel for the revenue. And Ms. M. Burman and the government advocate appearing for the respondent number 2, 3, and 4. She's for 1. If you notice a motion returnable in 4 weeks, requisite extra copies of the petition. Next, the pendency of the writ petition shall not be a bar for the, this representation of 2312 is before whom, or respondent 3? Okay, before the respondent 3 to
26 post, 26.
dispose of the application dated 23/12/2022 submitted by the petitioner. These are unnecessary litigations which are coming up, Mrs. Hazarika.
Lordship, otherwise there is a review authority is there, Lordship.
No, if it is not done against no action, there is no appeal. Do you find that if somebody applies for mutation and the officer doesn't work, there is an appeal provided for? You think there is a provision? Tell us that.
No, Lordship.
No, then what he will do? So you are piling up litigations, and someday we'll have to call people unnecessarily.
Lordship.
Somebody is applying for mutation, you don't do, he comes to High Court.
Yes, Lordship.
14.
You're there?
Lord, the matter relates to,
I issue notice.
my lord, notice will not serve the main purpose of this
Then?
petition because he is very seriously ill and under treatment of.
So what should I do?
Yes, so my lord, only call for the reports from the reports, respondent number 3, 4, and 5 for before this honorable court, and in view of the said report, lordship may direct the respondent number 1 and 2 to consider the master petition annexus 6 in a speedy manner. So it's time bound action is required in this case, my lord. Because
No, this court is not giving a direction to the governor.
no.
It's not within
I am not
our
praying for
domain.
that. I am not praying for them. My limited prayer before your lordship only to issue appropriate directions to respondent number 2, if required, and if it deemed fit and proper to this honorable court that to dispose of the mercy petition on the grounds availed by the writ petitioner before the honorable governor for speedy disposal. That is my limited prayer. In view of the report, if jail authorities and hospital authorities sent to this honorable court. So that's why I am praying for a time bound action in this case. Annexus 6, page 70 is the mercy petition. It was submitted before the honorable governor on 23rd of December. But since then, no action has been initiated.
Yes, Mr. Deori.
Yes, your lordship.
Because if you lordship will consider the photographs
No, photographs I am not considering.
and the medical.
If I
reports are
consider
also-
the photographs, there is life in Mars, there is life in what you call moon everywhere. We have seen movies, Star Wars,
No,
correct? So photographs don't depict anything.
but the medical reports are also annexed in page 62 onwards.
You see, I have got a lot of experience in looking at photographs, correct? You go to the MSCT courts, wherever they are, anywhere in the state, you stay for 5 minutes, you will find MSCT, what you call claimant, he can't walk when he goes to court. And after the proceeding is over, you will find him running away on the road. I have seen many things. Correct?
Yes, everything is possible. But
Everything is
the
possible, so
medical
don't worry.
reports are also speaks that.
Don't worry. We have seen people with gross injuries, and when they till the time they are referring to their injuries, it is okay. But once they show their injury, we find that it is a what you call a different ballgame altogether.
But here we have annexed all this.
No, it's okay, but this photographs I have no faith.
No. Annexure 4, page 62 to 67. Medical reports are also annexed.
It's okay, we'll have to see this one. Yes. What to do? Mercy petition.
Lordship. With regard to the respondent number 1, what they have to say on that,
We'll take it on Wednesday.
yes,
You get instructions
yes,
from the home,
yes.
correct? What
Yes.
is the impediment?
Yes.
Then we'll pass orders.
Yes.
Heard Mr. A. Paul, learned counsel for the petitioner. Next para, in view of the nature of prayer made in this writ petition, Mr. G. Deori, B. Deori, and government advocate. Phase 1 is granted time to obtain instructions. List on Wednesday in the motion column. Wednesday is 30. First, 31-3.
Lordship, can it be on Friday, Your Lordship, because
Friday will be some problem, my lord.
Since he's asking for mercy and showing health ground,
yes,
try to get it, only you need an oral information, verbal information.
Yes.
If the report of the home has gone to the governor's secretariat, end of the matter,
yes.
we can then close it. Because we can't issue a direction to the governor to do it in a town manner.
31st.
31st. Just get that information.
Let this copy be online.
Okay.
21.
Will issue notice. Heard Mr. K.R. Padgiri, learned counsel for the petitioner. And Ms. G. S. Erika, learned correspondent number 1,
Lordship.
and Mr. B. Deori, learned government advocate, appearing for respondent numbers.
Remaining all my.
For others, 2 to 6. Issue notice of motion returnable on in 4 weeks. Extra copies. The pendency of the writ petition shall not be a bar for the respondent authorities to examine the claim of the petitioner and to pass appropriate orders thereon.
Lordship.
Oblige.
Here also same thing, unnecessary litigations.
Matthew.
23, this is contractor bill. Okay, there is same order contractor bills, huh? There are earlier items also. Notice extra copies, the government advocate, who's appearing for the respondents?
I am for respondent number 3, Lordship.
You have for 3, Ms. G. Hazarika for 3. And others who are there,
Lordship, PWD will be Mr. B. Gogoi.
B. Gogoi, standing as a PWD for respondent numbers.
Only one is by us, I mean,
1 is by you.
yes.
I am
One
for
by
3.
PW.
I am for 3. Lordship.
Oh, okay, 1.
Trustee 2, 4 and 5.
Okay, 1 will be by Deori. 2 will be for 2.
PWD lordship.
2 is PWD, 2,
B-
4 and 5 is
2,
PWD.
4, 5, Mr. V, each or V,
I am for 3, Lordship.
and 3, Mrs. Hazarika.
Lordship.
Contract with pendency shall not be barred for the respondent authorities to examine the claim of the petitioner and to release payment if found due.
Oblige lordship. That is a loss.
Yes, I'll issue a notice.
My lord, only my lord, one letter, I like to draw your lord's attention, my lord, page 15, my lord.
What is that?
And this is the letter, my lord, in view of my application, my lord. Additionally, applicant Mr. Roto, respondent number 2, my lord.
I'm saying that they'll examine it and pass order. I can't do anything
my
more.
lord, for the last 14 months, they are not allotting rights to me, my lord, so I'm unable to distribute rights to the poor beneficiaries, my lord.
But I can't do anything about it. You want me to pass an ex parte order?
No.
No,
So, my lord, instruction is lordship.
that's what I'm asking. Heard Mr. P.K. Dekal and counsel for the petitioner, who is appearing for
Yeah,
all the
all of that.
respondents. Mr. B. Deori, the government advocate, appearing for all the respondents. If you notice a motion returnable in 4 weeks, requisite extra copies in course of the day. Next para. The pendency of the petition shall not be a bar for the respondent authorities to examine the non-release of NFSA rights to the petitioner and take remedial measures. Next, the petitioner shall be permitted to produce a certified copy of this order
My lord.
to the Deputy Director of Food and Civil Supplies and Consumer Affairs, Tezpur, Sonitpur.
Deputy President.
May it please Lordship. Lordship, I'm a partnership firm. In
Contractor
order,
bill, it's a contractor bill.
No.
please.
It's a bill, unpaid amount actually.
That's what I'm saying, contractor's bill. Same contractor's bill. Your name?
D Pathak.
D. Pathak for the petitioner. Your name?
S Boru on behalf of RV Bora.
SB,
BTC.
SB,
S Boru.
S. Boro on behalf of R. Borobora, Standing Council BTC. And for
One
your
and three.
1 and 3 and you're for respondent numbers?
Two.
Respondent 2. Contractor bill, payment, you gives copies today. Pendency shall not be about to examine and consider the, what do you call, examine the claim and pay, make payment if found due. Yes.
26.
Highly obliged.
These are the contractor's bills.
No, Lordship, there's other clauses. There's a liquidated damage claim that has been.
You will examine it.
Maintainability part may be kept open because I'm raising the enforcement of contractual obligations. There is
Is
a
it?
arbitration clause also. So maintainability part may be kept open, Lordship.
Okay. Heard Mr. MP Sharma and counsel for the petitioner. And Mr. B. Chakravarti done at CEC appearing for the
All the
for
respondents.
the respondents. As the learned CGC has raised a preliminary objection as to maintainability, keeping the issue of maintainability open, issue notice of motion returnable in 4 weeks, requisite extra copies in course of the day, next para. Notwithstanding the issue of maintainability, it would be open to the dependency of the petition shall not be barred for the respondent authorities to examine the claim of the petitioner. This after 4 weeks. Right. Yes, just a moment.
Lordship, at this stage, notice may be issued, Lordship.
Just a moment. Okay. Heard. Mrs. R. Chaudhary, and counsel for the petitioner. And Mr. C.K. Barwar, and government advocate, appearing for, you are appearing for all the respondents?
No, not for 1, 3, 5, 6.
Who will be for others?
Other for BTC.
BTC, nobody is there. Mr. B. Chaudhary, standing counsel for BTC, respondent numbers
2 and 4.
2 and 4. You should notice a motion returnable in 4 weeks, because it extra copies in course of the day. Pendency of the reparation shall not be barred for the concerned respondent authorities to examine the prayer of the petitioner for revoking the suspension of petitioner's license.
Order dated 14.
There is no private respondent, is also there, respondent number 7. Notice. has
Oh,
been
is it?
given.
I did not open it. So then, notice you say, petitioner shall take steps for service of notice on respondent number 7 by registered post with AD. And submit postal track report prior to the next date of listing. Pendency shall not be about then. Okay.
Yeah, please.
Yes, your original settlement period is over. I am not giving a stay, but I'll issue notice.
Settlement period is over, already new tender has been called and the last date is my lord 29th at 3 PM it will be open. So his case is that he's my lord praying for extension. Extension, my lord, board can they have a taken religion, but this is without approval of the government, we cannot pass a formal order for extension. So that, my lord, it is under consideration of the government, but not considered till today. So that's why we go for phase tender, which is going to be, my lord, open on Monday, my lord. So that is that case, my lord.
Whether that.
So as a matter of extension cannot be a matter of right.
Consideration has been given or not, that is still pending also.
No, but tender I am not stopping, whatever be the reason. If tender is floated, your original tender period is over, you are asking for extension of time.
No, lots of that has been approved by the board also.
That may be there,
approved by
but
the board.
by judicial order, I'm not encouraging that.
And the similarly situated petitioners lordship by the same meeting, they have already approached the Honorable High Court, and that is pending lordship.
Has the court stayed it?
No, there is
there
no
is no
stay, but prior to putting of tender, they have approached the.
Oh,
Honorable
that's
High Court
okay,
also.
but I'm not staying it.
No, in
Ten
fact, they
percent
are
I'm
getting
not
that
staying.
because my lord, they are by daily basis, they are doing my lord. But we have to, my lord, make it.
Otherwise the petition will become infectious.
Always you have a civil court for remedy.
No, lordship,
Show me that order you're trying to give.
lordship,
কোন কিটা কিছু? When I need that.
You see, Mr. Das, you are approaching the court and we are issuing a notice. In fact, in this case, a court should issue a suo motu notice on the state. How can they collect revenue from the roadside temporary vendors? This is something which is shocking.
it is within the
That
municipal
means
area.
that means you see, you are encouraging street vending, and then every day in the just take that, and every day they are.
And page
Go and go.
54,
Yes,
it is more
petition.
visible also. Page 54, item 1 is for parking, and page item 2 is for temporary roadside shops.
Okay. But Mr. D. Das, learned counsel for the petitioner. As well as Mr. T. J. Mohakar and senior counsel, assisted by Mr. A. Barwar and counsel for respondent number
1, 3 and 4.
1, 3, and 4. Will be appearing for 2.
2 with government, my lord.
C.K. Barwar, government advocate, appearing for respondent number 2. Next para. By filing this petition under Article 226 of the Constitution of India, the petitioner has a petitioner who is a sitting lessee
Yes.
for collecting revenue from temporary roadside shops and street vendors under Sivsagar Municipal Board. Is seeking a direction upon the respondent authorities has prayed for quashing of the tender notice dated 12/5/2023. Insofar as it relates to collection of revenue from the temporary roadside shops and street vendors under the municipal area of Sivsagar Municipal Board, and seeking a direction upon the respondent authorities to extend the period of settlement of the petitioner in terms of resolution number 1 within bracket GHO, GHA, bracket was adopted by the board in its special meeting held on 4/3/2023 for another period of 1 year. Next one, I should notice motion, you should notice the motion returnable in 4 weeks. Requisite extra copies of the petition is sought under state and departmental council in course of the day. Now, where is that municipal board rules which allows 100% extension for a same period? If a tender is for 1 year, extension can be for
Yes,
1
my
year.
lord.
Where is
The
that?
rule, my lord.
Lordship is
prior approval of the government. Rules for products, procedure for the sales and pound of the market, municipal, board, town and community.
Which section, which rule?
Rule for procedure for the sales and pound and market by municipal board and town committee in Assam. I see.
Yes, which rule?
rule 2.
The period of lease for the pound and market shall be 1 year, provided that the board may, if think fit, with the previous approval of the director of municipal administration, extend the period of lease for a total period of 2 years, but not exceeding 1 year at a time. Rule 2, my lord.
Okay, now why is the compliance of rule 2 before issuing a approval?
My lord, as
Prior
per
approval is not there.
not there, board take a decision, send it to the government.
Okay.
So it is sent, it is already sent to the government. my lord.
And it is mentioned in the, it is mentioned in the minutes. Lordship,
In
that,
the minutes,
there
it is
is
by
a-
not
there
page
is a
direction.
approval.
I'm just trying to know the law
I have,
first,
correct.
then pass an order.
There is a approval, it is reflected in the minutes. Lordship.
Uh,
That is approval, that is not approval, that is a send for
it
approval.
is- it is noted that the Sivsagar Municipal Board is stated to have taken a decision in its special meeting held on 4/3/2023 for extension of the period of lease of the petitioner for a further period of 1 year from 1/4/2023 at an enhanced value of rupees 5,49,754.12. And further considering that the tender which has been floated for the same work is scheduled to be opened on
29 vehicles
29/5/2023
at 3 p.m.
at 3 p.m. The Director of Municipal Administration within bracket respondent number
2. Lordship.
2. You're this. Will take an appropriate decision. Prior to the opening of the tender. Or pass such further orders for extension of the opening of the tender. Next paragraph. The petitioner shall produce a certified copy of this order. Certified / downloaded copy of this order before the Director of Municipal Administration. On the next working day.
That is in
And-
29. Lordship.
I'll try to give it.
Lordship,
I'll
can
try
it
to
be,
give-
can it be on the alternative way also? You can send the email also. That
Ah,
can-
yes, or by Donald copy by email at the address of the respondent number
That's number 2.
2. Or alternative, we make it alternative, certified copy or in the alternative. Okay,
Lordship, what I'm trying to describe, also the whole process of initiating the transfer is actually illegal because on 12/5, we have approached the Honorable High Court for seeking extension. On the same day, we have communicated to the municipal board. On the same day, tender has been
Municipal
dropped.
board can't stop unless there is a direction to stay. They can't do anything.
But we have communicated to the municipal board also.
Maybe, but it is prerogative of the, you see, if the authorities don't take a decision, the, what do you call, the administration of the country will not stop.
Lordship,
It
the
has to go on.
one prayer, Lordship, till the decision taken by the respondent number 2.
I'm not
that-
saying it.
No, Lordship, not
still not
the
happening.
seeking is that the tender may not be open.
Giving that authority to the director, approving authority, he will extend it.
Lordship,
That's how I've said.
Lordship. That must be prior to 3 p.m. on the day, Lordship.
They'll do it. That much the director knows.
Lordship.
And next is same,
29.
Next is same.
same
Next
in respect of parking,
So
is
This is
in respect of parking.
this is in respect of parking.
Lordship.
others is same.
That, what do you call, where will I find it? My secretary will have to note it. Where will I find it? What work?
Lordship.
Which page?
Lordship,
Nature of work will be there in that.
nature of work is paragraph 2, paragraph
That
3
is-
itself.
It was
Paragraph.
go, but it's go.
Paragraph 3
Paragraph 3 of the petition
of the
and
petition.
the minute paragraph 1 go.
Minus it is one go,
That's
GA. Of the same meeting.
the same.
Okay,
Same meeting.
okay.
Lordship, in item number 21, in page 67, there is a minor correction is required to be done.
Do it. Right.
Keep it.
Correct Mr. Mohanta's copy also.
Also, at page 67 of 28 goes to page 29.
No, it's okay, just make correction here also, otherwise he'll find difficulty
Lots.
tomorrow. Yes, item 30. Oh, 30 is same, 30 is same.
30.
Oh, 30 is,
30.
oh, okay, 30 is different. Okay, right.
Land of Silsor.
Yes, Mr. Mazumdar.
Here the case is, your lordship. My Patta land, which is situated outside the boundary of the NIT. Your lordship. Now the revenue official have implanted a RCC post on my Patta land without any initiation of any demarcation case or anything.
I'll issue a notice.
Yes,
So it's a land under that 1971 Act, also, Urban Tenancy Act, also 1971, land of Kasar also.
Huh?
So under this process, instead of coming here, the revenue court is basically the power of the deputy commissioner also. He could have filed an application before that.
No, but he may not want to jeopardize an interest. Because you see, he's not claiming anything. He's saying that he's the owner of the land
Patta.
and IT is trying to encroach it. So why should he go to court? He's
They
not
are already
seeking
everybody-
relief against the original landowner. He's saying that the IIT is trying to, the NIIT is trying to
Right,
encroach his
right.
land.
Yes. Listen, there is not a question of right title, also. That's why it's not going to lawsuit. The thing is there, lawsuit,
Yes,
as part of provision of this lawsuit, there is a provision of ejectment lawsuit.
Still rejecting.
no, you don't understand this. He is not wanting ejectment of anyone. He is merely saying that he has a plot of land which the NIIT is trying to encroach. NIT is what you call, it's an institution which is,
Yes, and in fact, the land of the NIT is adjacent to his land. Land of the NIT is adjacent to his land, lordship.
correct. So they've put pillars. He's saying that they should not put pillars. It is his land. It has to be demarcated.
Illegal plantation of RCC post pillar in the name of NIT, so that is the difficulty. That NIT is constructing post and pillar. So he is wanting the interference of this code, directing that NIT, you don't do this.
Correct.
So instead of coming here, I think, because the deputy commissioner has the power of the revenue code, he should have filed an application before that, and deputy commissioner could have under the 1970. That is my submission, lordship.
He can go to a civil court, but not to a revenue court.
No, there is no question of title, lordship.
Even a suit for injunction is maintainable, Mr. Sharma. Sharma Barua. Correct. So he can go there, but if it's a government who is trying to encroach his land, why can't he approach the High Court? The land can be demarcated.
And
They will go for
Now,
demarcation.
you go, see, look at page 60.
and in fact,
Read
also,
that.
if the land is to be demarcated, it's
Look at page 60.
sixty. This is the order, worship.
This is for a different land.
Yes,
But then, Mr. Mazumdar, there is a second question for you.
yes, sir.
Why in the earlier repetition you did not come for that relief? Why separate repetition?
No, this is a different petition. Okay? It is a different petition. My neighbors as approach. Here, your lordship,
Okay.
they filed a complaint before the Future Development Authority. That this is claiming to be an land and Future Development Authority stop my construction. Then I approached the honorable court and this honorable court directed to carry on my construction only upon my that land, not on any other land, your lordship.
And
Here,
lordship,
your lordship,
secondly, lordship, under this,
Just a moment.
lordship,
Yes.
under the miscellaneous
No,
provisions.
let
under
Mr.
the-
Mazumdar complete. Yes.
now, my learned friend, which is your lordship, Annex 3. It is a judgment entitled to your lordship.
Oh, don't go back to that history. Correct.
She is,
That is for you to satisfy the title.
Yes.
But you are now asking a restrainment on the NIT to put up pillars.
yes.
Correct.
Yes,
Now,
on my parcel.
no, let me understand. Now, supposing the IIT comes and says that this is my land, then what do I do?
Yes, that is the thing.
If they claim to be their land.
Then I will go there, measure the land,
no,
come
no,
back.
no. If the NIT says that is their land, they can always go for demarcation, your lordship.
And you can't go.
They are claiming your lordship.
No, they have already
Now,
installed.
for
That means,
immediate
no, you
release,
see.
your lordship, for protection
No,
for
no,
immediate-
Mr. Mazumdar.
Yeah.
His idea was right, question was wrong. You see, if a pillar is put, pillar can always only be put by a land revenue staff. Correct?
Correct.
That means land revenue staff has done the demarcation. Now you'll have to go to a civil court.
Now, I have filed a representation, your lordship.
No representative, now go to civil court. Now go to civil court because this is land dispute where I can't poke my nose.
Your lordship.
I can't do anything. If tomorrow somebody comes and says that this is my land, then what do I do?
I have come for immediate protection, your lordship.
No. Civil court is the best protection now. His question was right. I was issuing a notice, but when you made me read it, there lies the difficulty.
In same case, your lordship, this honorable court has interfered. Here, the election number 6, your lordship.
I'll give my reasons.
Yeah,
I'll give my reason, but this is not a fit case to be done.
this honorable court has protected. Your lordship.
No, it's that's why I read this again. When I was showing him that page 60, I have said, now you see, he doesn't protect you. It says that we clarify the petition and undertaking any construction. Then they will not be disturbed.
Yes.
So now you are asking the other side if they are doing construction, then they will be disturbed.
No, in that case, your lordship.
No.
The land was claimed to be. annexed.
You get a order for injunction. Not this way.
So I will approach the court. your lordship.
Mr. R. Mazumdar, Learned Counsel for the petitioner, seeks to withdraw this writ petition and to approach the appropriate court oblique forum for relief. With that liberty, the writ petition stands closed on withdrawal.
Oh. This
Yes,
case.
item 31.
Yes. This case is one, this case, case number, to be transferred to CIDP for further investigation.
Just a moment. Yes, what are you trying to say? I did not get it.
we want to transfer his PS case to be investigated by the CID, Lordship.
We'll have to issue notice. We can't do anything more.
This is notice of yours.
My humble submission before your lordship is there, my lord. Because the police has not properly investigated, investigating officer, I made allegation. And my lord, that was not investigation properly, my lord. In a murder case, my lord, there is a 164 statement. In 164, some accused person name has been mentioned, that arrested, my lord. Many things has been happened, I have stated. I filed a representation 24/1/2023.
It's not a question of,
Yes, sir.
you see, it's very simple. If an investigation is not being carried out, you have a remedy of approaching this CJM and having the investigation monitored.
Yes, my lord, that the 156(3) I can
Yes.
file, but in the instant case, what happened, my lord? I'm asking for the CID, they are not investigating properly. CGM has no power to transfer the case to the CID, my lord. That is why I filed this.
Oh, no, there's a Supreme Court judgment, even
I
even
understand, my lord, that is why-
even a CJM
Yes,
is
sir.
empowered to transfer a what you call investigation to the CBI.
No, my lord, that is not, my lord. Sikari Basu is something different, my lord. After your lord says Sakari Basu. There is a judgment, my lord. Rahira Habibullah Sheikh and other judgment, my lord. Where it is categorically stated, my lord, if the investigation was not done proper way, my lord, in cases like that, my lord, 302 and other cases, then it will be, my lord, investigated by the CBI. That is why I approached before the, my lord, investigating that, my lord, the director.
No, I'm issuing a
general-
notice. What else
Yes,
can I
yes,
do?
ma'am. Yes,
I'm
ma'am.
issuing a notice.
Yes, my lord.
Today I can't do anything.
Yes, ma'am.
Heard Mr. Anandi Chaudhary, learned counsel for the petitioner, and Mr. C.K. Barwar and the government advocate appearing for the
All right.
respondents. Next paragraph. Alleging improper investigation. The petitioner has approached this court under Article 226 of the Constitution of India, praying for transferring the investigation of Nagaon Sadar PS case number 67 of 2023 under sections 447 of the 302 IPC to the crime investigation department. Next, I should notice a motion returnable. This will have to give a short date,
Yes, ma'am.
3 weeks. Requisite extra copies of the writ petition be served on the learned State Council in course of the day.
Can it be, my lord, during the course of the day, my lord? Today,
Course of the day, because otherwise he'll not be able to transmit. If I'm giving a short notice, try to get and give it to him. Next para. In the meanwhile, the learned government advocate shall produce a report of the investigating officer in a seal cover. Full stop. It is made clear that the court does not intend to make the report of the IO made a part of record, as it may divulge, will disclose materials at a nascent stage of investigation. Next para, the learned government advocate shall transmit a downloaded copy of the order to the investigating officer of Nagaon Sadar PS case number 67 of 2023. We need a reporting seal cover. 49 I have to adjourn. I can't take up.
One election petition is there, my lord. Election petition case is there, my lord.
That is what I called 49.
There is a problem, my lord. There is an order, my lord, your lordship order, my lord, by order dated, my lord, 27/4/2020, means IA 284. My lord, my name is was withdrawn, my lord, but your lordship directed to register to my name, but inadvertently, my name is M. Bora, my lord, not M. Bora, my lord. So thereby my name is coming, my lord. Your lordship heard Mr. M. Bora, my lord.
Oh, okay. I'm sorry.
I'm M. Miron Bora, my name is.
Right. And Bora, it's a
That
typing
may be
mistake.
corrected, my lord. Otherwise, my lord, I may be covered.
Okay.
Inadvertently, my lord.
It will be in 284.
My lord. I number
Oh.
284, yeah.
284, yes. IA 284. Mr. N. Bora, the counsel for the petitioner, had made a submission on 27/4/2023 to withdraw from the case, which was allowed. However, due to inadvertence, the court recorded the name erroneously as Mr. M. Bora. Therefore, it is clarified that the name M. Bora, as indicated in order dated 27/4/2023, shall now be read as Mr. N. Bora,
Niran Bora.
Niran Bora, and counsel for the petitioner. So this, the order dated 27/4/2023 shall be read along with order passed today. Okay, we'll fix another date in this election matter.
My lord, a short date perhaps.
I'll try to.
6 June.
6 June. Yes,
Item number 46.
yes, 46.
My lord, it may be on Thursday, my lord.
What is it? Just give it to me.
My lord.
Just a moment. Other matters will be adjourned. I have to rise. There's a meeting. Mr. Sheikh had made a mention in the morning. Other matters will be all rolled over.
My lord, I can.
Just a moment. I'm taking up Mr. Sheikh's matter. Yes, Mr. Sheikh.
My lord,
What is there?
my lord, here in this case,
Yes.
my lord, before your lordship. My lord, your lordship would be pleased to see the last order. 21/4/23.
I've seen that.
My lord, here was a tea garden, my lord, of the petitioners on a scheduled land. The land is wasteland, my lord.
Yes.
So, my lord, our prayer before your lordship is this. The lordship will turn to page 19.
Yes.
That land we are occupying from 1990 and tea garden is going on. And
No, you see,
land-
you'll have to show us, number one, that there's an order of eviction. You have not stated that there's an order of eviction.
No, my lord. there is
Blanket
no
order of stay, how can we give?
No, not stay, my lord. Only thing is this, my lord. Only thing is this, my lord. My prayer is very simple. Land is wasteland. I am cultivating tea, my lord, from 1990. So, my lord, let my cultivation continue. But when government wants the land for any purpose, my lord, for any public purpose, then we are ready to vacate the land.
This is something which we can't give. You'll have to dismiss your writ petition.
My
The
lord,
writ petition itself will not be maintainable
my lord,
with such a prayer.
my lord,
You see, you must come with some grievance.
my lord.
Is it your case that somebody came and threatened you? Which authority
Yes,
came
my
and
lord,
threatened you?
That I am placing before your lordship.
Yes.
Your
Take
lordship will
it.
turn to page 15, para 10.
Yes.
That on 10th of February 2023, some people came to the scheduled land, identifying themselves as employees of Deputy Commissioner's Office and from Rongzoli and Dudhnoi Revenue Circle respectively, who asked the petitioner to cut down the tea bushes standing on the scheduled land within 20 days. Otherwise, they personally cut the tea bushes and thereby evicted
So,
the
Mr. Sheikh,
petitioners
in
from
today's
the-
modern world, where everybody carries a mobile, you can't take their photographs who have threatened you, number one.
My lord.
After, immediately after receiving threatening, you can't go to the Deputy Commissioner's office to give a protest.
Right.
You can't do anything. Just you are wanting a blanket order
Right.
of stay.
So, your lordship will consider my prayer, my lord. I'm not that, I want the land. Because, my lord, from 1990, we are continuing, we
No,
are
you may-
unemployed persons, my lord, we are.
By
doing
way of
some
an injunction, we are not perfecting your
cultivation, my
title.
Why? If the land remain vacant, my lord, nobody is benefited. We are collecting tributes, my lord, and your lordship, government will.
No, it is your
instruction,
choice. I have given you the choice.
My lord,
If you stick to their prayer, then I am dismissing your petition
my lord.
because you don't have a right. Unless
no,
you show your right,
I'm not claiming any right over the land, my lord.
then Mr. Sheikh,
My lord.
you see, the
And,
principles of Order 39, Rule 1 and 2
Eh.
is also required to be followed in a repetition.
Well,
Unless I find that you have a vested right, prima facie right title and interest,
In that case.
how
my
can I
lord,
give you an interim
may-
relief?
May I pray before your lordship, place before your lordship, 46, page 46. my lord.
I've seen that. That's what I'm asking you these
My lord,
questions.
Government already collecting cess against this tea production. my lord.
Mr. Sheikh,
Hello.
today a man has come to the income tax office. Right now, when we are conversing, a man has gone to an income tax office. He says that I have an income of 1 crore rupees, which I have done by dacoity, by theft, by murdering people, by looting the bank. I want to pay tax. What will the ITO do? He will take tax and keep that tax. But for the crime committed, can you say that, no, I have not committed a crime because I paid tax?
Your lordship pointed out Dakati, my lord. It is not Dakati. 4,000 people.
It's not that,
engaged in
I'm
this
just
thing.
giving an example. It may be inappropriate, but it is still an example. You see, unless you show me a right title in interest, I can't give you an injunction. That's why I said that I have got ways and means to dismiss your
Let the
petition.
government obtain instruction, my lord. Last occasion, government has been directed.
No,
to
it will
obtain
not give an instruction because you see, if somebody, let us, you see somebody, you come and tell me that in the High Court gate, somebody threatened you. Now, what can I do? If you can't identify that person, if we can just see the CCTV, in the CCTV doesn't, nothing comes out. What can I do? What can the police do? Then you say that no investigation was carried out. You must give me some leeway to do anything.
In that case,
If
my
you
lord,
merely say that somebody has come and threatened you, why won't you go to the Deputy Commissioner's office and give a complaint? Why you don't go to the police and lodge a complaint?
in that case, my lord, I will approach the deputy commissioner.
Huh?
Yes, sir.
So what do you do with this petition?
My lord. My lord, with that observation, my lord,
We'll close it.
yes, I will approach the deputy commissioner.
Okay, heard Mr. M. A. Sheikh, learned
Detail,
counsel.
detail representation.
Okay, you have heard us, just allow him to withdraw the petition. With liberty to approach the Deputy Commissioner. Which district?
Goalpara, my lord.
Goalpara,
Yes.
with an appropriate application for relief. Okay,
Please, my lord.
yes,
My lord, item 54 and 55, I would like to mention for listing. in the
give it to all these players to the court master.
Appointment of
My
arbiter.
number is 69 and from the last 2 days, I'm just waiting there. The matter is very urgent, that is already.
Tell him to the court master, he'll do it. Correct.
Item number 79. By Monday.
Monday is not possible. I have an election and pattern matter coming up on Monday.
Tuesday as a first.
Tuesday can take it.
Wait, please, your lordship, it's most on my lord.
Let him adjust because I can't.
My lord. My lord.
Is it Monday? Wednesday. It goes to Wednesday.
Item, my.
First time.
No, I'm not giving in my item. There is no first item. There is every-
79.
You make me a prayer, I'll upgrade and take it up. Mr. Sheikh made a prayer, I upgraded and take it up. You just tell me we'll take it up.
But my lord,
I just need only 2 minutes to argue that matter. If
my
you-
lord, item 73,
Just tell me
74.
the court master.
And there before I start was listed with the urgency because on
You
29
see, I can't do
But
anything.
yes,
Monday and Tuesdays
on
are fixed
Tuesday,
matters.
Monday lordship is
Monday and
without
Tuesday are partnered matters and fixed matters coming up.
final
Election matters are
total
there.
list has been going to be published on Monday. That's why it was they will start was listed the lordship.
Yes,
did
it
today.
can be done.
On Monday lordship.
Monday.
Item 73, 73, 74.
The meeting has started.
Yes.
Honorable Chief Justice is chairing a meeting. Tell me the court master.
Content notice may be issued, my lord.